Halk yılda bizlere yardım etmeye çalışıyor. Lütfen yardımcı olun. Kahramanmaraş'ta dursun.
ಕೋರ್ಟ್ ಆಫೀಸ್ ಇದು
is attached to the benefit. This is a letter of assistance from the lecturer.
she has to be madam ಬನ್ನಿ yes yes
My lord, see number 39, my lord. See number 39.
Sir, wait ಮಾಡಿ ಸರ್, ಕಾಲ್ ಔಟ್ ಮಾಡ್ತೀನಿ wait.
Agud.
what is the petition? ಏನಾಯ್ತು ನಿಮ್ಗೆ? ಏನ್ ಮ್ಯಾಟರ್? ನೀವು ಯಾರು ಗ್ರಾಂಟಿನ ಪರ್ಚೇಸರ್? ಗ್ರಾಂಟಿ ಏನಾಗಿದೆ ಇವಾಗ? ಅವ್ರಿಗೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಅವ್ರ ಕಡೆ ಆರ್ಡರ್ ಆಗಿದೆ, ಪರ್ಚೇಸರ್ ಕಡೆ. ಪೊಸಿಷನ್ ಯಾರಿದ್ದಾರೆ? Next week, or take some date next week. Which date you want next week? ಯಾವ ಡೇಟ್ ಬೇಕೋ ಆ ಡೇಟ್ ತಗೊಳ್ಳಿ. 27 next week. Next week. What is the relief you are seeking? For what? NOC for what? Have you applied? Next week. Claimant. ಯಾವ ವರ್ಷ? ನೀವು ಹೇಳೋದು ನಿಮ್ಮ ಮೇಡಮ್ಗೆ ಕೇಳಿಸಲ್ಲ ಪಕ್ಕದಲ್ಲಿ ಅವ್ರಿಗೆ ಕೇಳಿಸಲ್ಲ ನೀವು ಹೇಳೋದು. Who are you? Who are you? How many years delay? Next week.
Page wise adjournment. Page 7, serial number 26. Page 8, serial number 27 to 38.
Registry to list CP number 88/2022 along with this petition. We list week after next. Yes. At request of counsel for petitioner. Relist week after next. There is a stay. There is a stay. Stay the entry. Yes, Salwa. Madam, you are able to hear me. Stay the entry. Request of counsel for respondent. Relist next week. Request of petitioner relist after 2 weeks. Interim, with the interim order, if any, is extended till next date.
Page 9, serial number 39 to 43.
My lord, 39, my lord. I have to take steps. The R3 council is elevated, my lord. Now I have to take steps, my lord. That's what the cause list says. Kindly grant some time, my lord. R3 is elevated as High Court judges.
Who appears for R3? Who appears? Harish Bandari.
Yes, sir. Hereby. Yes.
But we are not aware if he is elevated.
Ill-
Mr. Sri Shaila.
Yes, my lord. Yes, my lord.
R3.
That's what cause list says, my lord. R3 council is elevated as High Court judge, therefore.
39.1. No, who had filed? You all right, doesn't matter. Relist at request of counsel for the insurance company. Relist this matter next week.
Yes. 2 weeks, my lord. I will take steps.
All right, 2 weeks.
Much obliged.
The one ನಿಮಿಷ ಅದರಲ್ಲಿ
Hail, sir.
already service of notice is gone. New steps ತಗೊಳ್ತೀರಾ. Court has to issue notice to
Oh,
R3.
court, kindly do it, my lord.
Issue
I
court
wanted to
notice
make
to
that.
R3.
Yes. Court
Issue
notice.
court notice to R3. Just take up who's the Rajesh Rai ಇರ್ಬೇಕು.
Page 10,
Serial number 43, my lord. Sorry, 42, my lord.
42.
Yes, my lord. I pray for 2 weeks time, my lord.
At request of counsel for petitioner relist after 2 weeks.
Much obliged, my lord.
Then a counsel for the petitioner submits that talks for settlement is in progress and she seeks time, same is granted, relist after 2 weeks. Interim order, if any, extended till next date.
page 10, serial number 44, 45.
At request of 1 week. Who are you? Defendant, plaintiff, yeah. Plaintiff or defendant?
Your Honor, my colleague is there.
Petitioner, relist after 2 weeks. Interim
Your
order till next date.
Your Honor, a small submission in this matter. I am for respondent number 1. Date may be given, Your Honor.
No, sorry. Next.
Page 11, 45.1. Page 12, serial number 46 to 49.
Right? When did you come on record? Huh? What is your name? Vasant? Vasant Raja. Other names can be deleted. Except your name, other names can. Learned Counsel Sri Vasant Raj has filed wakalat on behalf of petitioner. Registry to delete other names apart from Learned Counsel Vasant Raj in the cost list. Relist after a week.
Page 13, serial number 50 to 54.
Request of counsel for R3 to 6 released next week. Interim order is here. Interim order, if any, continues till next date of hearing. In the meanwhile, counsel for petitioner to furnish one set of writ papers to the counsel for R3 to 6.
Page 14, serial number 55.
Give orders. Hmm. Hmm? When did you file? All right. So he's filed in Bengaluru. You filed in Ramnagara. He has appeared in the matter at Ramnagara. Learned counsel for the petitioner. Issue notice to respondent. Counsel for the petitioner is permitted to take out notice on the counsel representing the respondent before the court at Ramnagara or at Bangalore. Orders on I1, there shall be stay of all further proceedings in MC number 6244 of 22 on the file of second additional principal judge, family court, Bangalore, till next date of hearing. Who are you? When is the sale? When is the sale? When is the sale?
Application was given in the year 2006 after that 10 years. On 2022,
There is order.
65.
What has he ordered?
He added
But learned counsel for the petitioner. Or who's Chandrasekhar, there's some caveator. No representation on behalf of the caveator respondent number 5. Learned HCGP accepts notice R1 to R3. Issue emergent notice to R4. 5 idhar lucky way. Learned counsel for the petitioner to serve copy of the petition to learned HCGP and also to the caveator. Caveator yourself. There shall be stay of all further proceedings pursuant to the order passed by the Deputy Commissioner, the second respondent, dated 12/12/2022 in number RA capitals. Bar SC/ST bar 33 bar 2021-22 till next date of hearing.
Serial number 3, my lord. I appear for Karnataka State Law University, my lord. Copy is served upon me, my lord. I am not directed to take notice, my lord. Subsequently, I'll take instructions.
Yes, what do you want? Or learned counsel for the petitioner issue. Notice to the respondents, learned counsel Srimati Sarita Kulkarni
Please, my lord.
is directed to accept notice on behalf of respondent number 1. Emergent notice to R2. Counsel for petitioners permitted to take out hand summons to R2. Read it after how much time you need?
My lord, the day after, my lord, I'll take instructions.
All right, next week.
Please, my lord.
Next week.
Obliged.
The filing. File it in the office. Learned counsel seeks time to file necessary application during the course of day. Is permitted to do so. Relist this matter next week. Week's time granted to rectify the objections. What is the objection? What is the objection? To whom? Notice to whom? You have a stay. What is a stay? What is the suit for and who are you? Who are you in the suit? What is the suit for? Read us this matter on 10th to rectify the objections. No relief you are seeking against R2. Learned Counsel files a memo seeking dispensation of notice to R2. And also submits that R2 was placed ex parte, is placed ex parte before the trial court. Accordingly, notice to R2 is dispensed at risk of a petitioner. Relist week after next. Interim order, if any, extended till next week. 2 weeks granted if needful, then issue notice to unserved respondent. Same, 2 weeks time, needful, then issue notice.
My lord, in serial number 8, my lord, notice in respect of R2 may be held sufficient, my lord, which is returned as not claimed.
No, it will not be held sufficient. You have to take out notice.
Please,
If it is refused, it will be held sufficient. Please take out once again.
please,
2 weeks time, 2 weeks granted.
grateful, my lord.
Hi, CH.
R3. You have to take steps for R1 and 2. R3 is abated. So that you have to file IA. Once it is abated, it's abated. Huh? Delhi. And why you did not bring to the notice of the court? What is the steps to be taken within 1 week, failing which writ petition stands dismissed? So a writ petition will be dismissed. What about R1 and 2? Sir, do you see the cost list? Or do you know what is happening in the court order sheet? You're behaving like you don't know anything and you want the judge to tell you what is the status of your case. All right, work out. By order dated 16/4/2021, this court has passed a peremptory order which reads as under: steps to be taken within 1 week, failing which the writ petition stands dismissed. You have not taken steps from 2021. Delhi. Then you have taken 2 steps not taken in respect of deceased 3. IA2 paper publication filed is returned with office objection. When did you file that? 21/4. What is that office objection? You are taking paper publication for whom? But our game paper when he's dead. Do that application, paper publication. Please don't behave so ignorant. You're a counsel, supposed to be learned counsel. Where are these R1 and 2 residing? Mention that now. I'll allow your application. Why can't you mention? ಎಲ್ಲಿ ತಗೊಳ್ಬೇಕಿದ್ದು newspaper? In Jharkhand or West Bengal? ಎಲ್ಲಿದೆ ಅದು? ಅದು ಯಾರು ಬರಿಬೇಕು? Which edition you have to write? Not appearing. Correct it now. Now only you correct it. Barkol. Counsel for the petitioner has filed an application seeking permission of this court to take out notice by substituted service through substituted service by way of substitute service through newspaper publication in Samyukta Karnataka of Bangalore edition. Which edition? That goes to Tumkur also. Party iradilri. So no, whether they have separate Bangalore and Tumkur edition or what? I don't know. You have to tell me. Going to Mr. Government, whether Bangalore edition is different from Tumkur edition. It's different. All right, Tumkur edition. The office objections with regard to the respondent number 3 being deceased is accepted by the learned counsel for the petitioner. And when did you file the memo with regard to R1 and 2 being the LRs of R3? What do you have the file code? See whether it is there. When did you file 2.8? The counsel for the petition has filed a memo dated 2/8/2022 by way of a memo stating that the LRs of deceased R3 are already on record as R1 and R2. In view of the same, I took up this application IA number 1. What is that IA number? IA number 1 of 21, full stop. I have perused the application. Application deserves to be allowed. Accordingly, it is allowed. The petitioner is permitted to take out notice through by way of substitute service through Samyukta Karnataka daily newspaper of Tumkur edition as against respondent number 1 and 2, which shall be taken on showing the date of hearing as 15 days. Showing the hearing date as 8/3. Application is accordingly allowed. Counsel for the petitioner is permitted to carry out the necessary amendment, which shall be done during the course of day. ಇದು ಮಾಡಕ್ಕೆ ಎಷ್ಟು ಇದು ಮಾಡ್ತಾರಲ್ಲ, small correction you don't want to do. Huh? Full cost title. A week's time granted at request of counsel for petitioner. Two weeks time granted if needful done issue notice to unserved respondent. Two weeks time granted to take out notice to respondent number R3, respondent number 3, failing which list this matter for dismissal. Meanwhile, counsel to serve copy of the petition to Learned AGA. This is coming up for 5th time. Next.
Appear for petitioner serial number 13. The copies have been served on respondent number 2 and 3 yesterday, my lord, and government is already served. And process is taken yesterday for respondent number 1, serial number 13, my lord. I appear for petitioner.
Learned counsel submits that he has done the needful registry to verify in order issue notice to R1.
Much.
Learned counsel is permitted to carry out the amendment during course of day and also permitted to file the amendment petition by serving copy on the other side. Relist next week. Is it there? No. Is it a batch of matters are already there? BMS. So revaluation is there in the regulation. Only retotaling. All right, we'll see. Kodi. Relist this up 2 weeks. All right, next week. Next week you carry out the amendment. Now, I don't know when that is coming up. If that is allowed, that it will follow. A week's time granted at request to rectify your objections. 2 weeks time granted to comply. What is the relief you are seeking? What is the compliance? Sir, what is the compliance objections? What is the office objection raised? I late. Third learned counsel for the petitioner should emergent notice to the respondent learned AGA accepts notice for R1 and 2. NCISM is Manasi Kumar. Manasi Kumar have been learned counsel Srimati Manasi Kumar directed to accept notice for respondent number 3. Who appears for KEA? Learned counsel Sri N.K. Ramesh directed to accept notice for respondent number 4. Learned counsel B.S. Sachin to accept notice for R5. Registry to show their respective names in the cause list. Counsel for the petitioner to serve one set of copies to all these respondents. Counsel for the respondents. And meanwhile, comply with the objections raised by the registry. Felix, when do you want? Huh? We list on Friday. Mr. Halashetty, you are amicus. You are directed. What is this GMCPC? Why she is asked? What is this recalling IA?
Her father said not to send you, to send together with other students.
Sir, I will tell him to come inside.
Speaker ಇಟ್ಟಿತ್ತು ಹಂಗ ಅಪ್ಪಂಗ ಗಂಡ್ರ ಟಾರ್ಚರ್ ತಂದ ನೋಡ ಮನೆ ಕೈಯ
ಸರ್ ಮ್ಯೂಟ್ ಮಾಡ್ಕೊಳ್ಳಿ ಸರ್.
What is the stage of the petition? Final year. Rule was issued. Rule was issued. What are you challenging? We'll allow this application and hear it.
Matters to be heard tonight. She is not put in the service for the last 8 years. Now it comes and dictates. Because
No, who are you? Who are you? So you are aggrieved by some order of the appellate tribunal. You will allow the application in here. Call. No, the application for recall go objection ಆಗಿದ್ದೀರಾ?
To be issued and work orders be appointed as teacher. No, the respondent hearing does not have a application.
That you can argue on. That you can argue.
Application be allowed.
That is your IA. IA 1 of 22. Learned counsel for the petitioner has filed application IA number 1 of 22 under section 151 of the Code of Civil Procedure to recall the order dated 26/8/2022, by which order the petition came to be dismissed for non-prosecution. Full stop. Where have you stated that the matter was listed for final hearing after rule being issued?
Not stated that the matter was listed for. Who is issued, but the matter was listed.
It is submitted by learned counsel to the petitioner. An interim order was granted in favor of the petitioner and the matter was listed for final hearing, on which day the counsel for the petitioner sought for adjournment. Same was rejected. The petition came to be dismissed for non-prosecution. Having perused the affidavit annexed to the application and on hearing the submissions of learned counsel for petitioner as well as learned counsel for the respondent, I deem it appropriate to allow the application, as the matter will have to be heard on the merits of the case and disposed of accordingly. Since the matter was dismissed for non-prosecution, it's appropriate to recall the said order accordingly. IA number 1 of 2022 is allowed. Order dated 26/8/2022 is hereby recalled. The writ petition is restored to its original file. We decide on merits, delist this matter. When we'll fix a date? 15th? 16th February. 16th. You're a party, no? You're a party to the proceedings. Why amicus are appointed? She's not represented.
Here represented by advocate, but appointed an application to assist.
Huh? Okay. The previous advocate is not there on record. All right, I'll hear you. 16th. 16th is okay with you? No, he wants to have. Huh? No.
Evidence. Okay.
All right, the fact remains that there's a mistake of OS number. So very simple. Recall that order, then you can argue on merits and dispose of whether he successful. ಅದು ಇವರು ತಪ್ಪು ಮಾಡಿರೋದು advocate. ಅವ್ರಿಗೆ ದಂಡ ಹಾಕ್ಬೇಕು. ಇಲ್ಲ ನೀವು ಬೇಡ ಅಂದ್ರೆ ನಾವು ಹಾಕ್ತೀವಿ. ನೀವು ಬೇಡ ಅಂದ್ರೆ ನಾವು ಕೋಟ್ ಹಾಕ್ತೀವಿ. Maybe that he should know that as an advocate. He is not a layman. That is why he is learned advocate having completed law course and how many years of practice. Can't do such stupid mistakes. Heard learned counsel for the petitioner. IE 1 of 2022.
Pradeep Singh. ಇವನು ಸೆಂಟ್ರಲ್ ಗವರ್ಮೆಂಟ್ ಕೌನ್ಸಿಲ್
Under section 11 the code of
ಟರ್ಬನ್
August 2020.
ಇವನೇ ಕೆಮ್ತಾ ಇರೋದು ಪಾಪ ಸರಿ ಇಲ್ಲ.
Whereby this court, on the basis of memo filed by the petitioner, dismiss the present writ petition as having become infructuous. The petitioner has filed an affidavit along with the application, wherein he has explained the error committed with regard to wrongly mentioning of the suit number OS number 89 of 2015, which is a subject matter as another writ petition, whereas the present writ petition is the subject matter of the suit in OS number 63 of 2007, which is still pending adjudication. Same is stated in para number 1 and 2 of the affidavit. Having perused the same is bona fide and satisfactory, and it is accepted. Accordingly, the order dated 18th August 2022 is hereby recalled. The writ petition is restored to its original file, subject to the condition that the petitioner deposits. How much cost has to be imposed on you? Ajita A. Shetty, you are not on record. It's okay. All right, that is unfortunately his father is no more, but this application for the error committed he has to pay. What is the cost? 2,000 rupees to the Advocate Clerk's Benevolent Fund. Release next week. Yavagide arguments. All right, you say this out, place this order there. File a memo. You don't know what to do. Then why you want advice from the court? All right, we'll have it next week. Give a date. 15th. What's this? Learned counsel for the petitioner is permitted to take out notice of this petition on the counsel representing respondents number 2 and 5. So, 5. What about reporting death of P1? Who's petitioner number 1 is dead. You have filed wakalat. You have filed. Paper publication for whom? 2 and 5. So you want to take out paper publication for 2 and all. IE number 1 of 2022. In view of the order passed by this court today, IE number 1 of 22 is kept in abeyance. IE number 3, 4, 2, 3 and 4 are of 2022 are filed by the petitioner seeking to condone the delay of 538 days in filing the LR application to bring the legal representatives of deceased petitioner number 1. ಎಷ್ಟು ಜನ ಇದ್ದಾರೆ? Deceased petitioner number 1 on record and to set aside the abatement. And counsel for the petitioner, LRs of the petitioner number 1 has filed wakalat on behalf of the LRs of petitioner number 1 along with these 3 applications. I perused the affidavit annexed to these applications. The reasons assigned, cost shown therein are satisfactory and the same deserves to be allowed. Accordingly, it is allowed. The delay of 538 days in filing the LR application is condoned. Abatement as against petitioner number 1 is set aside. The legal representatives of deceased petitioner number 1 is permitted to be brought on record as petitioners number 1A and B. Stop. Senate counsel for the petitioner to carry out the necessary amendment and also file an amended petition by serving a copy of the same on the other side. Stay ಆಗಿದೆಲ್ಲ ಇನ್ನೇನ್ ಬೇಕು? Who are you, plaintiff or defendant? You have come before the court. Next.
Number 21, Ramaya Gowda again.
Appearing for respond number 1, 2, 6, 8, 9, and 12.
Not there, respond number. So respond not.
All right. Then at counsel, the postal shara with regard to service of notice to R5, 7, and 10 is returned as refused. Same is held to be sufficient and deemed as served registry to show the names of R5 and 7 and 10 in the cost list. Who appears? Anybody appearing for 5, 7, and 10?
Let's, I am appearing for 1, 2, 6, 8, 9, and 12.
9 and?
Name 12 melons. Name is shown as Ruben Jacob melons.
You're not appearing for 5, 7, and 10?
No melons. I am not appearing for 5, 7.
All. In view of the above order, application IE1 of 2021 would not survive anymore as they are held to be sufficient. Hence, same does not deserve any orders to be passed. Suit is for what?
Yeah. We are good private referral, not that. He entered in compromise.
You are not a party in the suit. Who was entered into the compromise?
Declaration based on adverse point.
So, as on date of that compromise, your mother was alive. Who's the GP holder? So what is the relation? What is the relation with your mother? What are you questioning here? Do you have any stay here? No stay granted. Which year is the suit?
Yes, 2001.
Is this matter on 14th? Released on 14th.
My lords, if I may make a submission, my lords, it may be taken up on 17 or 18. My lords. I'm traveling from 12 to 16.
All right,
My
released on
apologies.
17.
Grateful.
Yeah. It was heard for some time. Mr. Nayak had argued. We start here. Monday will have it. All right. At request of Learned Council for the petitioner released on 13th. Interim order, if any, is extended till next date.
In this case, appear for implementing applicant, my lord. In serial number 23, appear for implementing applicant, my lord.
Who has filed this recalling order?
Lord, the petitioner has filed the.
What is that?
Lord, he wants to recall the order date 25/11/2022, my lord, which has been passed by the Sound Court.
What is that order?
Lord, it's a RTS students were not admitted to the class. Subsequently, the Honorable Court directed the petitioner to allow the students into the school, that is to attend the classes. So that they want to challenge and recall that order, my lord, which is dated 25/11/2022, my lord. It's exam times, my lord. It's exam time. Yes, my lord. Yes, my lord.
They are the affected students.
Now, who's now filing this application to recall order of 2511?
Petitioner, my lord.
Or you? Who? Who's the petitioner? School. How are they aggrieved by this order? So they are not in favor of the RTE students. So what?
They voluntarily admitted, my lord. Subsequently, they are not allowing, my lord. If they are not allowed initially itself at the inception, they would have joined the other some other schools in the jurisdiction area, my lord.
Who are you appearing for?
I am for the students, my lord, including applicant, on behalf of the students, parents, my lord.
This was heard earlier by me.
Some extent it was heard.
All right, you file amended. How much time you want?
My lord, the exams are will be starting very shortly, my lord. So for the students, let it not affect this. Let this not build.
Permitted by the order of this court.
Yes, my lord. Because if at all, if the day
on 2511. However, in the meanwhile, petitioner school shall allow students who are kept away from attending the classes forthwith. However, said as subject to result of repetition.
Yes.
Now, is there any exam ensuing coming up?
Yeah, this yearly exams will be, annual exams will be.
You are permitted to attend. Anybody stopping you?
No, because if at all, this should not disturb the students.
Let them attend. Don't stop them.
Please, my lord.
List next week. Request of counsel for petitioner. All right, he's seeking for a passover. Let the council come. Passover means it will be called again. His council will come. We will take it up later after some time. Main object is to be important. The portal of Matrimonial. Different queries that they have. The number of queries, one of the queries belong to this. Now, if she writes that she is studying in Udapur, then her father is studying in father is employed in Haveli. Now, Aadhaar card she will be having in this thing. Father may be having in Haveli. Because at the age of 4 or 5 when she joined the college, these things is. So, if she gives false information, tomorrow at the time of verification, she will be disqualified. Now, they have come up with points method.
The very formation of the portal and the enquiries, they have done it on a basis that the have a Navodaya, they have the Navodaya. If the father is in different, so that the rationale how they are going, different networks are going. Find the logic of the. An interim order to participate in the qualification and to fill the form to go to the next stage, if you are going to be issued another entity. Then if you are not qualified, it is subject to the result of an interim order will be passed. Otherwise, we will define our policy. For the central government.
Oh. This is formed under the society's registration. Page number? Yeah.
Depends if parent is not staying there, study. If the parent is staying there, then if they don't have I already there. Then they say, and they say the website portal, not portal. But this doesn't the portal to for any government residential certificate of parent in the district is candidate in the last. Any document. Then after application to accept by the website, then they will publish those documents. This document, usually what you have Some students they used to get one certificate studying in another business and not residing there. So one.
That is the second stage. Now, first stage is only taking in the application. All right. Now he is still in the first stage. Yes, Mr. Kamath, what is the difficulty? You want admission. You're seeking admission for 6th standard. Fill up this.
What is the details what they are seeking? One column is there called alarm. This is measurement of the moment. Of residents of the study is the same. So if you say no, the next portal everything is possible. It will not come at all. I am not qualified. If I say yes, then they will ask for the next step. Is the study certificate? If I say yes, then whether the candidate has been promoted from class 4 and educated in class 5 for 31st, I must say yes. Then it will come, do you have Aadhaar number? Moment I press Aadhaar number, it will be of the system.
No, apart from Aadhaar, there are other documents which you can furnish.
Here, what is the column? Do you have Aadhaar? There is no other document. The technicality here is only this by law. Technicality is only this. The next column is not the moment my father is. What's the matter? It's not one or two students, about 500 students. All the volumes. The 6 students have come here because the discussion council has taken a lead at the government. My humble submission is there, we will not put the students difficulty. My learned friends here are the next. That is why it is different. Now let them put a example, their tax and they are anxious in all there.
Now the portal is open. Open. When is it closing? Now, if in case they don't have Aadhaar for whatever reasons, for example, is there any other document that they can? No, whether it is giving such an option in that column number. Ideal.
Yes. Parent is there, I am not qualified. Go further. The moment I say no, I will be giving wrong information. Go for wrong information, I will be. So my submission is why is the reason the subject is new for all of us? The Bombay High Court has gone in detail, but has not completely held that what is the issue between the whole. Yeah.
It's very same issue. Yes, read it. Hmm. Paragraph 6. Hmm? Hmm. Yes. So your case is your student of the same district. You're seeking where, Haveri or Sirsi? No, you're seeking admission in which district? Sirsi. But you are not a student of, a resident of, then you are not entitled. No, forget about this order. The rule itself says, the prospectus says so.
I can appear in 60. I can, if my father is not in 60, then I am not entitled to 60. Because I did not read Haveli, my father is in Haveli, I am not entitled to Haveli. This rule they have brought this year. This judgment is of last year, 2022, because decided in October. What if I kindly see page 14 of the judgment, the introduction my lord. So, okay, the learned counsel for the petitioners are very here the petitioners are seeking admission in Jawahar, Navodaya, Vidyalaya, PhD, for short sampling, institute and Ratnagiri, August 21. Guidance and for admission for the academic. Ask them for training or for service. Petitioners being eligible for regular school. Admit card in the second week of April 21. Some was scheduled on 13. Tests were conducted. Petitioners were selected upon according to the learned counsel, certain commitment does not apply to the school. Documents seeking it like the over. Reliance upon clause 2.1 guideline, however, 3.1 relying upon submitting candidates on the basis. They have seen last guide the appearing for the LLB. So, in presence of CC, I should get admission only in CC, not in the Haveli. That's no circumstance, the second candidate will be given admission in the LLB. Further, relies on 4.3 research. It very class 5, the whole of the academic government aided or other National Institute of Open Studies, the same district, further submits the document to the case of LIOS studies. Learned counsel further relies upon the form of the resident. Said the form is also meant for the student. The guidelines by the for the year. Now the guidelines have changed. How the guidelines say. How the guidelines say.
4.1.
No, you have to kindly see in page 5. Resident certificate, the valid residential proof as notified by the government of the parent of the same district where the JM cards I shall be published.
Hmm.
So if my father is in Haveri, I have studied in CH. Portal will not accept.
No, this is after selection. This is after selection.
No, now only.
No, please read the heading. Please read the heading of the page
Document will be submitted after selection. That's all.
after selection.
Now, 4.1 if you not read.
So 4.1 is at the time, please understand, 4.1 is at the time of entry. After you get selected, then they will call for this records. You produce it. If you are suitable and coming within that, then you will be selected. Otherwise, you will be rejected.
If I give it false declaration here I will not be selected. So it is quite.
No, you need not give false declaration. You give correct declaration.
In the portal from where I have studied. According to their rule at 4.1.
No, is your Aadhaar card belonging to some other district? And where have you applied?
I have applied from Sirsi.
Then what is it? Let it be, you are having Aadhaar card of Sirsi, you are entitled.
No, my father is from Sirsi. I am from father.
No, sir, please understand. If you have studied in the same year, in the same district for the 5th standard, then you are entitled to take up for 6th standard in the same district.
Only the bona fide resident of the district concerned, where the Jawahar Navodaya Vidyalaya are eligible to apply.
Where are you reading? Where are you reading?
Page 4.1 of the petition. Who is eligible?
4.1, yes.
4.1. Only the bona fide resident candidate of the district. Where the candidate has studied last 5 and appeared as for the JLB is to be submitted by the provision itself.
Yes.
JLB to work for this. For the purpose of
That cannot be.
if the case a new Vidyalaya is not started, candidate has to decide in the district where he or his city education, the JLB located in the same district, followed by the residence certificate of the parent district, time of verification of document after provisional selection. Candidate has to agree. Submission is not. But submission is only this. That is not more into the technicalities. Case, because it was of the application and the rules that was formed for 2021. Now for 2023 selection, but the simple thing is that this has been discussed in total by lot for about 1 hour. Oh, my father's Haveri. If I say that I don't have Aadhaar card, then I will be giving you a false information.
If you have Aadhaar card, you see, give the Aadhaar card. If you don't have Aadhaar card, then thereafter you will continue to write the exam at the entry level. Odi? No, your Aadhaar card is of Sirsi. Then what's the difficulty?
It's not the same. It's another.
When the Aadhaar card Sirsi, how it will say no, you can do correct and then it will go through. You are fulfilling the criteria. If your Aadhaar card is Sirsi, sir, you forget about. No, sir, you are confusing yourself. That father's thing is a next level. First level is that if you have to belong to the same district, then you can apply for that particular Navodaya school. If you are in Haveri, go to Haveri. If you are in Sirsi, apply in Sirsi. If you are having Aadhaar card, you show the Aadhaar card, it will permit you to enter. After you enter, then the provisional comes, and then after that, the selection process happens. I don't find where is the difficulty.
India as a whole has to be taken. Whether I have Sirsi Aadhaar card, I have Haveri Aadhaar card. Future of the six.
No, you can't decide that.
I can decide that.
No. Mr. Senior Counsel, you are entitled to come before the court and agitate your claim, but it doesn't give you any locus with regard to the policy making of the state.
No, policy making of the
It is made.
I can need it.
No doubt.
I can study anyway. Just because my father.
This is a scheme. This is a scheme formulated by the government of India. All.
Take it to the portal now. We will see what will be the result. Suppose if it doesn't accept, suppose he cannot go for the second round again, we will know the result by 2:30.
No. There is no rocket science in this. If you are a resident of Sirsi, if you have Aadhaar card of Sirsi, if you have participated or had the 1 year previous of 5th standard in that particular district, then you will be entitled to do. That is the law, that is the prospectus of the Navodaya Vidyalayas. This is to benefit certain section of students.
Come in the portal that the parents are. I cannot move to the next. This is the difficulty that has been created in the.
All right, you go and apply now. Let us see. Or what? No, what interim order?
Taking necessary modification in the format. Otherwise, in the.
How can that interim order be granted? You are asking them to make modifications in their portal, which is not even main relief sought by you. What kind of a prayer you ask? You are not challenging.
Earlier, this Aadhaar card issue was not there. So there was not much issues to the parental going to the court. Now the petitioners are permitted to apply. Now not applyment. Other part disqualify Agudilla because there is an order. This order.
No. How this court can pass an order contrary to the regulations which they already have for a set eligibility criteria?
Criteria they have got now without naming a proper rule.
That is challenge the rule.
No, without having.
Won't apply now. You are saying that you are having Aadhaar card of CC. Don't apply online.
we'll just apply which what's.
All right, just find out. We'll find. No, you find out if the Aadhaar card is taken from some other place. For example, he is now applying for Sirsi. Please wait 1 minute, understand first. He is now a student of Sirsi seeking admission for Sirsi, having completed 1 year of 5th standard in Sirsi. Now you are asking Aadhaar card. Suppose he has taken Aadhaar card in Haveri, then that will not match. But the fact remains that he has been in Sirsi for 5th standard and a resident of Sirsi. Then there's a conflict. If they have given some provision for such kind of students. So find out whether that is available. You sit with him, Mr. You sit with him. That's why they have given this whole list. Have you not been provided this list? Mr. Kamath, this list is given of other residential certificates. If you don't have Aadhaar, you can give this.
That the residential follow is not.
We call this matter at 4 p.m. What is this, Mr. Gomez? Grantee or purchaser? Grantee or purchaser? Rejected by the. Does Aneshwari? Yes. Yes. Yes, yes. What about notice to the others has not gone? For whom? Leonard, there's no representation on behalf of petitioner. Leonard at CGP accepts notice for respondent number 1, 2, and 3. 1 and 2. You are appearing for Panchayat. Leonard Counsel Devraj. MS Devraj accepts notice for respondent number 3 and 4. Issue emergent notice to 5. R5. Devraju anta. Released after 2 weeks. Huh? Copies are not given to you. No representation on behalf of petitioner. Grant counsel for the petitioner to serve one set of copy of the petition to the counsel for respondents. Next.
Number 28, release
There has been rejection of the application on in page 22. After 2 years, my lord, I have made an application on 15/1/2020. Page 22 on 17/10/22. It says that in the 172nd syndicate meeting held on 2/9/22 and 5/9/22, decided to reject the proposal. 5 was sent to the Honorable Vice Chancellor with details. 4 reasons are granted. The conclusions leading to this order, my lord, was on 2/12/2020, that is annexure C in page 6. Notification was issued, my lord, inviting for affiliation to reform forces. They have stipulated, my lord, which is in page 9, column number 6, calendar of events. And the last calendar, my lord, was May 21, being the last day for submission of proposals to government to issue of orders. This, my lord, at page 30.
Where does this say for which course? Where does it say for? Huh? Where is it saying? In annexure C? No, the notification inviting application. Where does it say it is for B form?
Page 27, part C.
But there are several notifications.
Yes, there is. Our case is that there were 2 inspections, my lord. After we submitted the application, first inspection is at page 49. That was all clear. Which is the first inspection dated 23/6/21.
Page? Which page?
Page 49.
49.
49. 49. This is the inspection for fresh affiliation done on 23/6/21. A second inspection at page 84. See that dated 1/8/2022. Only criteria 1 not available. All others shows available. Criteria given by the Pharmacy Council that section L, page 70, with reference to timeline, now please turn over to page 71. Paragraph 6. As per judgment dated 30/12/2012.
Yes.
Supreme Court in Principal Plus, regulatory body concerns the power of to process and APM. All state governments and examining authorities are requested to complete the process. By the deadline fixed. Similar institutions, my lord, with certain non-compliance in page 143 are given conditional permission. In page 143, the bottom. Further decided.
143. Yes.
Further decided above approvals is subject to submission of consent or application. Examining authority, staffing of the above parliament, for making admission. No admission shall be made without submission of consent. Examining authority. Case of consent by examining authority is not reached. That's again not page 145. So there are similar institutions, including in page 188. That is SLES College of Pharmacy. They're given conditional permission.
No, you said that there's a deemed approval.
All I'm saying, my lord, is there's
In fact, the contrary deeming is withdrawal.
all I'm saying is they're given permission. What I'm saying, my lord, there was a timeline. Procedure to be followed. There have been 2 inspection reports. It's a minor non-compliance. And in a one-word order, they say it is rejected. And naturally, annexure B, which is by the Pharmacy Council, was the rejection by Rajiv Gandhi University, followed up by the rejection by the Pharmacy Council at page 23. Yes, in page 25. The top part, the petition institute. I'm already running the DFARM course, which there is no objection. DFARM course is because I have not got the consent for affiliation from the university. Therefore, the NOC will not be granted by the state. That's my.
Yes. Who has to answer this?
The notice annexure A. Item number 16 is the orders of the.
Yes.
And item 14 is the minutes committee.
All right, R1 and R3 will have to answer. Pharmacy Council will give take notice on him. Heard learned senior counsel Sri Ajesh Kumar, is it? Ajesh Kumar on behalf of learned counsel Dilip CG for petitioner. Learned EG accepts notice for respondent number 2. Shimajan notice to R1 and 3. Learned counsel BS Sachin is directed to accept notice, take notice for respondent number 1, who was appearing for Pharmacy Council. SS Haveri. The learned counsel SS Haveri to accept notice for respondent number 3. Learned counsel to serve copies on the respective council. Yes, what is the urgency now? Correct, sir. So we'll have it next week. Get it served. Let him say why. Next week, let him come and say why he is not. If there is some minor ones, we can order for another inspection, and if you are complying with it, it can be release this matter next week. Sorry? Oh, all right. Okay. I thought you were designated as senior counsel. All right. In the senior advocates also. Then you have to file wakalat. All right, something to be. Otherwise, he may make allegation. I never authorized Ajesh Kumar has come and argued his name is. No, I have encountered such situations. Both in all the 3 places, Kalburgi, Dharwad, and also in Bangalore. That exemption is only for senior counsels. That's
There's a provision in the logical review. Zero problem.
no. Now we are further bringing more amendments to Section 34 of Advocates Act. How and who has to appear before the High Court.
With minimum problem. I don't know.
No, it is accepted. Advocates are welcome to appear, but something on record to protect your interest, not the protecting, because they should not blame. It is very easy, you know, some next advocate comes and says, I never authorized. What happened? No, whether you are willing to take your wife back and live with her. Why did you appear before Davangere? When did you appear before the mediation center? Court officer. What is this? So you are ready to take her back, or you want to separate? All right, now you tell the court what do you want. All right, you go before the mediation center at Bangalore. Where are the parties residing? Where is the report of the mediation? Whether it is failed, not failed. Where are the parties residing? You're in Chalakare, Chitradurga. You're in Davangere. All right, both of you come before this court at Bangalore. Third learned counsel for the petitioner as well as counsel for respondent. It appears that though this matter was referred to the mediation center, at Davangere. White order dated 9/1/2023. It is submitted by learned counsel for the respondent that nothing transpired and the petitioner wife was really interested in transfer of the petition rather than discussing with regard to possibility of a amicable settlement by way of mediation process. Hence, he submits that if the matter is referred once again to Bangalore Mediation Center. ಮತ್ತೆ ಅಲ್ಲಿ ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ನೀವು ಟ್ರಾನ್ಸ್ಫರ್ ಬೇಕು ಅಂತ ಕೇಳಿದ್ರೆ ಮೀಡಿಯೇಷನ್ ಪ್ರೊಸೆಸ್ ರೆಫರ್ ಮಾಡಿ. All right, here the order. Both the parties to appear. In ಬರ್ದ್ರಿ? When you appear and do the process of mediation, what's the difficulty? Davangere have already ordered and you have not done anything.
I am ready from now.
You are ready. If he is not ready, then you have to work out some possibility of a mediation process. If you are absolutely not interested in separating, then you can stick to your stand. No, nobody is forcing you. Or at least participate in the proceedings. You have 2 children. ಮತ್ತೆ ಯಾರು ನೋಡ್ಕೊಳ್ಬೇಕು? ಏನ್ ಕೆಲಸ ಮಾಡ್ತಾ ಇದ್ರು? She is working. She is a constable. ನೀವು ಮನೆಯಲ್ಲೂ ಕಾನ್ಸ್ಟೇಬಲ್ ಆಗಿ ಬಿಹೇವ್ ಮಾಡ್ತಿದ್ದೀರಾ? Why have you filed for divorce? No, why have you filed for divorce? Already go once again to the mediation process and both will explore the possibility of an amicable settlement. Hence, the matter is referred to mediation center at Davangere. Both the parties shall appear before the mediation center. On when will you appear? When you will appear, when is the date now in the family court? When is the matter before the JMFC? Alright, both the parties shall appear on 1st March. 1st March. On 1st March. And the mediation center shall appoint a senior mediator to mediate the matter between the parties with regard to the proceedings, that is the divorce petition filed by the wife and the restitution that is being sought by the petitioner. The divorce petition is filed by the husband. And the contention of the wife to join the husband. If the reconciliation or mediation process fails, refer the matter back to this court immediately. Interim order extended. Right, do you have any objections for transfer? Let it be. Marriage consummate agli agderli, that is a matter of main to be decided on merits. Huh? Where are you? You're in Kunda. Anything have you filed in Kundapura? Warrant was issued, right? But what is the stage? What is the stage? What is the stage of proceedings? All right, where is the requirement of appearance? Is the requirement of appearance? There is a law that she has to first go and appear and then only file CP. No, you are willing now for settlement of take. You want to join your husband? You show your interest first, what you want. You don't want to join your husband. Madam, why don't you express what you want? Why are you worried what he wants? What you want? You want divorce or you want to join? Explore, go before the mediation. If he's willing to take and withdraw, then join him. Your purpose is solved. Children are there. Okay, what are they? 25, 31 years, drop of the hat, you want to come before the court. What is the distance from Kundapura to Chitradurga? Huh? Already you go before the Kundapura court mediation center. From where? Huh? Heard learned counsel for the petition as well as learned counsel for the respondent. For the learned counsel, learned counsel for the respondent submits that the petitioner has not appeared before the court at Chitradurga, and he has filed this petition without exploring the possibility of a settlement of through mediation process. There is a contention of the petitioner that she is interested in joining the respondent. In view of the same, both the parties are directed to be present before the Bangalore Mediation Center. When will you appear? When do you want to appear? So you are both are working. You are not working. All right, appear on 22nd, or you want on 28th? On 28th February, without awaiting for any further notice, at 3 p.m. Interim order is extended next date. Prakasha. Do you have any objection? Yes, yours? What is he doing? Working as driver. Yelli. What driver? Private driver, KSRTC driver. Okay. Join. Now, what happened after compromise? What is the petition filed in Gadag? Yes, what's the difficulty for you to join after a compromise? Do you want to continue the divorce? Children are there? All. Will transfer it. But this petition is filed seeking by the wife seeking transfer of the matrimonial proceedings in MC number 20 of 2021, pending on the first additional principal judge family court at Gadag to the senior civil judge Madhugiri, Tumkur district, wherein the matrimonial proceedings initiated by the petitioner wife in MC number 129 of 2020 is pending adjudication. 126 of 2020 is pending adjudication. It is a contention of learned counsel for the when based on that compromise, it was closed. Who has reopened it? Who has reopened it? How you can reopen the compromise? Where is our order sheet? Compromise angry reopen madtira unless it is set aside by a proper court of law. Where is that? Where is that? Padial. No, this is the joint. Where is the order of the court? The installmental ಕೊಡ್ತೀರಾ ಒಂದೊಂದಾಗಿ. Give me that joint memo. The petition is dismissed. Now it is not pending anymore. Now your section 9 petition is pending. Correct. Huh? Transfer to Madhugiri. You want transfer of this petition? Which petition? Filed by him. No, after this compromise, you did not join together. Barlila. Yes. I should allow your petition. You go and join your husband. Then why did you agree for the compromise? What is the distance between Gadag and Madhugiri? Then you have to withdraw your petition, file fresh petition. What is the prayer? When is that compromise? (14/8/21). Have you stated so in your petition with regard to this compromise? No, in this have you stated? Delhi Odi. All right, now that she has divulged this information, now she wants transfer of this section 9 because you are having certain other relationship which is unable to come and join you. Agree, I agree. That's because she agrees. You think she's a chattel that you will tie her up some in corner of your house, and you commit all illegalities, immoralities. That you work out there. In Bardari. No, cancel that. No. Last sentence, delete money.
Family got gathered. Senior civil judge
Madhugiri, they are pending there. It is a contention of land counsel for the petitioner that the petitioner that she had filed a petition for divorce under section 13(1)(1)(a), 1(b) of the Hindu Marriage Act before this civil judge senior division at Madhugiri in MC number 126 of 2020, which petition came to be dismissed on the basis of a joint memo filed by both the parties, and an order came to be passed by the court dismissing the said petition pursuant to the matter being referred to Lok Adalat, as it was the intention of the petitioner to join the respondent husband. But pursuant to the dismissal of the petition, the petitioner has, the respondent has not accepted the petitioner, and he has started harassing and torturing her, apart from having illicit relationship with any other woman. Hence, the petitioner, though willing to join the respondent husband, has refrained herself from joining him in view of his nefarious activities. The petition filed by the respondent husband at Gadag is still pending adjudication, which is filed under Section 9 of the Hindu Marriage Act for restitution of conjugal rights. It is a contention of petitioner that she is a resident of Madhugiri, which is at a distance of 200 kilometers, 350 kilometers from Gadag. And she'll have to travel all the way from Madhugiri to Gadag to attend the proceedings, and would have to incur expenditures on her stay, accommodation, and food. And she also contends that there is threat to her life from the hands of the respondent. Under these circumstances, the counsel seeks transfer of the petition. Petitioner seeks transfer of this petition from the civil judge, principal judge, family court at Gadag to the civil judge senior civil judge at Madhugiri, Tumkur district. Learned per contra, learned counsel for the respondent vehemently contends that the petitioner has not bothered to come and join the respondent pursuant to the joint memo on settlement agreed. And has failed to abide by the terms and conditions of the compromise. He also contends that the proceedings before the court, senior civil judge court at Madhugiri, has been dismissed and nothing is pending adjudication in the said court. Hence, the petitioner can travel to Gadag to attend the proceedings filed by the respondent husband for restitution of conjugal rights. Be that as it may, fact remains that the petitioner is a resident of Madhugiri district, Madhugiri Taluk, and the same is around 350 kilometers away from Gadag, wherein the respondent has filed the petition under Section 9 of Hindu Marriage Act. It will be more difficult for the petitioner to travel, and the cost will be more, which will have to be paid by the respondent. On the contrary, if the respondent attends the court at Madhugiri, he may not incur much cost towards travel of the petitioner along with an attendant for stay, accommodation, and other aspects. Hence, in view of the same, I deem it appropriate to grant the relief in favor of the petitioner by transferring the petition pending before the civil judge, principal judge, family court Gadag, to the civil judge, senior division, Madhugiri district. Accordingly, I pass the following order. The matrimonial proceedings in MC number 20 of 2021 pending on the file of first additional principal judge, family court at Gadag is ordered to be transferred to the senior civil judge at Madhugiri, Tumkur district. No order has to pass.
Right.
Fourth addition. All right, Barcode. Petition is allowed. Proceedings in MC number 16 of 2021, pending on the file of Senior Civil Judge JMFC Kollegala, is ordered to be transferred to the fourth additional Principal Judge Family Court at Bengaluru, wherein the petition filed by the petitioner in MC number 217 of 2021 under section 9 of Hindu Marriage Act is pending adjudication to be tried along with the same. Accordingly, petition is allowed. Where is Sadashivaya? There's an order of stay. You have an order of stay.
I represent the respondent. Sorry, Malad.
Sadashivaya.
Please, Malad, please.
We'll transfer the matter.
Malad, actually, the earlier proceedings have been conducted at Chikmagalur only. Malad, she has already obtained the maintenance from this respondent hearing. Now, once again, Malad, she wanted the transfer petition to the Chikmagalur only. But earlier, Arsikere is now not far away from that place. It is only 45 kilometers from that place. And I have been regularly maintenance amount also. For that reason, Malad, I requested. Malad, they also filed a criminal petition under which Malad anticipatory bail has been granted by this court.
Where is that? Where is that?
Malad, I placed along with the objections. Malad. I got all the documents, certificate copies.
No. The criminal proceedings are filed by the wife. Where?
Yes, true, Malad. True, Malad. She wants the transfer to the Chikmagalur only.
Sir, are you able to hear me?
Yes, Malad. I'm here.
Criminal cases filed by the wife in which court?
Criminal case, Malad, earlier, if you are filed, that was Chikmagalur only. Malad. Criminal case number 72 of 2020. It was disposed of on 16th December 2021, Malad. And thereafter, Malad, she filed a 438 petition in the year 2021 at Chikmagalur. And
438.
Yes, Malad, 438 for bail petition was filed. Anticipatory bail was filed before his court.
Who was filed?
The husband, Malad.
Okay.
Complaint by the wife. Malad, he obtained a petition before the this Shumug, what we call.
The distance between Hassan and Chikmagalur?
It's hardly 45 to 50 kilometers.
What's the distance? So if it is posted to Arsikare, Chikmagalur. No, if it is posted to Chikmagalur, where you're residing, where is the family court located?
In both the cases.
How many buses you have to take? Now you have to take 3 buses.
No, sorry. Every 10 minutes there is an alternative bus. It is the.
There is no bus. We can bus from here.
Is there any children from the marriage? Or what's the difficulty for you to travel? He's paying maintenance already. You've taken maintenance. You're willing to pay the cost of travel?
Yes, no, travel charges make it will be ordered.
We will pay the cost of travel. What insecurity? Huh? You travel with attendant, he will pay the cost of the attendant also.
There is no allegation.
You can't have the court next door to your house. What is the, madam, check, what is the distance? Huh? 60. You have stated 70 in your petition.
Yes.
Don't magnify merely because this court is lenient towards women. Relist next week at request of counsel for the interim order extended till next week. Next date I'll allow madam. Already date is given, I cannot change that. After 2 weeks. 35. So next date I'll allow it to be present. You're agreeable for transfer. What is the distance? Harihara to Bangalore to Harihara. 340 kilometers. Already you can't participate. Already you are attending the Section 9 petition. Have you made appearance in that Section 9 petition? Taken notice. And already 498 is filed against you. DV Act is filed. DV Act is filed. What is filed, sir? Delhi. The DV Act under Ade alone. All right, I'll transfer it, go there and attend them. Huh? Body. Barkali. This petition is filed by the petitioner wife seeking transfer of the matrimonial proceedings filed by the respondent husband in MC number 126 of 2022, pending on the file of the 5th Additional Principal Family Court, Bangalore, to the Senior Civil Judge Harihara, Davangere District. It is a contention. Really? Do you want Harihara or you want Davangere Family Court is there? All right, you go to Davangere. So, all right. You are resident of Davangere?
Yeah.
It is contended by learned counsel for the petitioner that the marriage having solemnized on 14/12/2013 at the Harihara, Davangere district, and pursuant to which there is a minor a son born by name Yuan, who is now aged 5 years, is in the care and custody of the petitioner. But the child is with you. So you have the child. It is a contention that the first respondent has caused harassment and cruelty to the petitioner, and she was driven out of the matrimonial home. And she is now presently residing with her parents at Harihara, Davangere district. Further contends that there's a life threat situation to the petitioner, and hence she could not be feasible and appropriate for her to travel to the family court at Bangalore to attend to the proceedings initiated by the respondent husband, the section 13(1) and 1A of the Hindu Marriage Act. It is submitted across the bar by learned counsel appearing for the petitioner that a petition has been referred under section 125 of the CRPC by petitioner wife, which is pending on the file of Harihara Court, Harihara at Davangere Court. What's the number?
89.
Same is 89. Same is 89 of 2022. It is also submitted that the petitioner wife has filed proceedings under the Prevention of Protection of Domestic Violence Act against the respondent husband, which is also pending before the court, before the court at the civil judge at Harihara, Davangere district. Full stop. And on these grounds, he seeks transfer of the proceedings filed by the respondent husband from Bangalore to the court at Harihara or Davangere family court. Stop. Per contra, learned counsel appearing for the respondent husband contends that the petitioner has left the matrimonial home herself and the minor child is in care and custody of him, and he is taking care of the welfare of the minor child. He further contends that it would also be difficult for him to travel from Bengaluru to Harihara, and he is agreeable if the matter is transferred to a middle place, that is Chitradurga, which would be convenient for him to attend to the proceedings at Chitradurga. Having heard both the learned counsels, I am of the opinion, admittedly, the fact remains that admittedly there are two petitions filed by the wife, one under the provisions of section 125 CRPC, which is pending before the family court at Davangere. Family court at Davangere in the aforementioned petition number 89 of 2022, and the DV Act proceedings are pending before the civil judge court at Harihara. And also another petition in MC 84 of 2022. 84 of 22 is pending on the file of family court at Davangere, preferred by the petitioner wife under section 9 of the Hindu Marriage Act. You have taken accepted notice there. The respondent has admittedly accepted notice in all these petitions and is participating in the proceedings before the court at Harihara as well as the family court of Davangere. Fact remains that the Bangalore to Davangere, the distance is 250, around 250 kilometers. In view of the fact that the respondent is already attending to the proceedings at the family court at Davangere, I deem it appropriate to grant relief in favor of the petitioner, transfer the petition of filed by the respondent husband at Bangalore to the family court at Davangere to be tried along with the MC proceedings filed under section 9 in MC number 84 of 2022. Stop. Accordingly, I pass the following order. The matrimonial proceedings in MC number 126 of 2022, pending on the file of 5th Additional Principal Judge Family Court, Bengaluru, is ordered to be transferred to the family court at the family court Davangere district to be tried along with MC 84 of 2022. Which court it is pending? One day Nairadalli. Davangere. Accordingly, petition is allowed. ಯಾವುದು 39 ಅಲ್ಲಿ ಅದು because of that R3 council is elevated in the 39.1 court notice is issued to R3. ಇನ್ನೂ 5 ಇದೆಯಾ 39.1 ಇದೆ. Some more matters are there, but how many more? Registry to list the following matters along with these two, please. You are ready in all these matters? Yaro? Will you take notice for R3? Oh. You have instructions to take notice. All right. And learned counsel so and so. It is already adjourned. I mentioned R3 issue court notice ಅಂತ ಮಾಡಿತ್ತಲ್ಲ ಬೆಳಗ್ಗೆ ಅದರಲ್ಲಿ learned counsel Harish Bhandari T accepts notice on behalf of R3 and he submits that there are few other appeals pending. Hence, following appeals be listed along with these appeals. Relist after much time you want? 2 weeks. after 2 weeks. Okay, you are accept ಮಾಡ್ತಾರೆ. In other cases you have taken. Asover.
Next year.
Your owner of the vehicle. Shantaraj appears for whom? Claimant. So liability is faster. $20?
Taken place on 28.
28? No, you filed statement of objections by saying that you transferred the vehicle. The proposed owner not made a party. Learned counsel for the appellant is owner is present before the court. There is no representation on behalf of claimant and insurance company. He is not here. Time period limit contrain. Hence release this matter. Next week you will argue. Learned counsel for the appearing for the owner submits that he has filed an application under Order 41 Rule 27 on 11/9/17 registry to verify and put up the same. Ready? We'll have it in the afternoon in comments instead of interruption in between. (45.1 and 2). 3 matters. What do you want? I'll take it up. No, you want to take up or you are seeking adjournment? What makes you think I'm not going to take it up? I don't know how much time he's going to take and she's going to take. But I'm sure they are not going to take 1 hour or 1.5, 2 hours. You, how much time you will take, Mr.? So you can come accordingly after. Friend ಬರ್ಬೇಕಲ್ಲ ಅವರು. All right, give a date. ಅವ್ರು ಮಾಡಬೇಕು. They have to. Shantaraj is for claimant. He's seeking enhancement. Their insurance company are B Pradeep. Interesting process, right? Turn up on. Where is the central government, Mr. Shashikant? Already you wait, if he comes, I'll take up your matter. You wait, Mr. Next. Now the 230 Mr. Ruben, you're appearing in the 230 matter. Who's the other side?
I appear for R2 in this matter, Your Lords.
Where is Girish? Mediation. Since how many years you are practicing? No, 1 varsha. Mediation is important or High Court is? When is the exam? You are now seeking for 4 evaluations. Average of 4. Average of 4. Just to take for the next exam. What is the difficulty to follow the earlier order what was passed by this court? Oh, you ask him whether he is able to come today. After finishing mediation, he can come. I'll call this matter at 4. No, you tell him to come. No instructions. Next. You can attend to other work your colleague can be. Where is Sachin? Sachin Allah or Madam Ivaga appear adralla. Girish, on behalf of Girish, she appeared Allah. Illa, now even Girish is here in this also. Girish for R4. No, who's R4? Rajiv Gandhi. Rajiv Gandhi, either Sachin or Girish. I think Girish is fine for color.
My lords, I appear for the respondent 4, my lords. Karthikeyan, my
For
lords.
whom? You are appearing for on behalf of Girish.
No, my lords. On behalf, I represent myself, my lords.
On
I filed
behalf
my
of
wakalat
Rajiv
in-
Gandhi.
Yes, my lords.
No, in which matter you are appearing?
36606.
Hmm? 5.2. Karthikeyan, you are appearing for Rajiv Gandhi.
Yes, my lords.
Divergent people appear, two different people appear.
My lords,
Advocates.
no, my lords.
I hope your arguments are also same and not different.
No, my lords. It will be the same, my lords.
All right. So we will continue. You can address on behalf of RGHS. In case you want to call Mr. Girish to come, it's up to you.
I'll do that, my lord. I'll get in touch.
Short arguments about consent. 2016-17, 2017-18, 2021-22, 2022-23. Permission has already been granted.
That you have stated in your synopsis? No. You in your writ synopsis you know. No, all right, you can say. What is it granted to you?
2016-17, 2017-18, 2021-20.
What about 18-19?
Those are the matters.
19-20?
19-20, 20-21.
All right.
21-22 and 20.
Granted.
Some. What I'm saying to the Lord is this. The Lord consider the order asked earlier on 6-6. 6-6-22.
So you are before this court for 2018 to 21 for non-grant of what? Renewal? Permission for
That academic year. And our basic premise
for the same number of intake. What is the intake? You are not seeking excess of.
My Lord previously told me, sir, that is student 80. I can be moved to class.
That is by which order?
Seven.
20.
This all. Admitted.
Yes, more read the. Just 2-3 more.
Starts with this one, existing.
Yes, I have.
This institution did not have necessary infrastructure. Currently, the petitions are filed under virtue of the interim order. Students are being exited. The actual petition is not is from any council. However, under the peculiar facts and circumstances necessary to protect it, but at the same time, the petitioner institution cannot be allowed to lose money. Hence, respondent 2 is directed to state how it proposes to safeguard the interest of the students and the action that can be initiated against the petitioner institution, and also how it is treated similarly placed institutions. We take this is allowed, and the fact that 21, 22, 23, permission has been granted. What I submitted for my lord is the which goes through the argument, the common argument, is that there was a calendar stipulated by this for which permission I suppose they were supposed to conduct an inspection. And after they were supposed to petition 4721 of 2000. Petition 4721 of 2015.
Yes.
You see the calendar, which is that in page 50, dated 1st September 2017, election E.
Page.
Argument would be
Page.
50. Election E.
Yes.
Yes. As per the provisions, new medical colleges, new higher courses, study, training, and increase
One. Mr. Karthikeyan is in this matter.
Yes, my lords.
Are you able to hear the learned counsel?
Yes, my lords. Not very clearly, but yes, my lords. I'm trying to make out.
Tap the mic. All right. Yes.
Yes. Provisions
Yeah.
of the establishment of new medical colleges, opening of new higher courses, training and increase of admission capacity of higher college regulations. The applications are received in the month of April and have to be disposed of by 31st March. However, it has been observed that the present process is cumbersome and time consuming, making it difficult to dispose of the application time. Therefore, in order to streamline the process and time schedule prescribed for giving the application received at 12 years of the semester, existing Ayurveda, Siddha, Unani, Homeopathy, ACUNH, central government has prescribed the following guidelines for strict compliance. New applications, that is, common number 1, and 2 is for existing colleges. Inspection of colleges by council and submitting of report and recommendation to the central government from 1st January to 31st March. Decision of the ministry by 31st May. On this background, my lords, please to see proceedings which leads to be confused. Which is that Annexure C. They start with the show cause notice, which is at Annexure A in page 16.
Yes.
Lord will be pleased to notice the date of the show cause notice.
Yeah.
Dated 9/8/2018, and it is issued under section 13A of the Act. 13A, my lord, I valid on that for new colleges. And here they say, my lord, in the first paragraph, I'm directed to refer to the ministry reference dated 27/7/2008. Forwarding there is recommendation and inspection report of your college visited by the CCIM on 23rd, 24th, 5/2018 to reassess the available facilities of teaching and practical training, as well as to verify the compliance submitted by the college. This color should have been done by 31st May. On examining the same in terms of the universal requirement standard, they say, my lord, it appears that the college is not following requirements. There is one yoga teacher in so against the relaxed requirement of any 5. Web-based computerized central registration system is not available. There is one emergency medical officer short against the requirement. There are one physiotherapist, one house officer. Functionality of the operation theatre, functionality of X-ray. 7 is web-based data. Please note that paragraph 4. Please note that as per the so-and-so policy, submission will be reviewed to the possession and agreement and detailed in the agreement, this is Pension Council regulation. Paragraph 5, we are asked to produce all the documents. Here, my lord, my submission from my lord is that they conducted inspection. They don't share the report with me, say what I should do. So that will be on the list. Second aspect is that they commenced proceedings in August. It should have been actually completed. That is insofar as the show cause notice. And it should be in page 19. I give a reply. I'm not going to come my finding which required by them and by me. More on the procedural aspect. So one aspect, my lord, is that they don't produce the or give me the recommendation and inspection report. Second is the timeline. And then comes annexure C, which is I think page 21. 10/10/2018. They passed this order.
This is by the government.
Yes. And my lord is pleased to turn to paragraph 5, where they say as a prefix. Whereas on examining the case in light of the notified and on perusal of the verification report, observed that the college has not basic deficiencies or cost. Paragraph 6. Whereas considering the deficiencies observed in paragraph 5, college was given an opportunity of hearing and to show cause why the permission to take admission course under section 8A not be denied to the college. The college was instructed to make oral and written submission. College was represented by Dr. Gail Dome, principal of the aforesaid college. Representation of the college submitted oral and written submissions. Now the reason, my lord, this is the reason in paragraph 7. Whereas in view of the observation of the hearing committee, based on the submission made by the college representative during hearing and the recommendations and visitation report of CCIM referred to in paragraph 3. Paragraph 3 is, my lord, first instance. It can be understood that as per the notified and approved norms of the in paragraph 4 above, the representatives of the college would not produce sufficient document evidence to substantiate their claim. Then around please turn the page over, paragraph 9. Therefore, in view of the shortcomings and deficiencies, particularly about non-availability of the required part-time teachers, hospital staff, and in addition to web-based computerized central registration system functioning, operational theatre, functionality of X-ray, ECG, and other based relocation system, non-teaching staff and hospitals violate provision of the IMC. Therefore, it's concluded, it's hereby denied permission for taking admission to BMS course of 60 students under 31A. Further, it is informed the college is provided period up to 31/12/2018 to fulfill the shortcomings served during the year, as mentioned above. The following requirements for the CCM in the area of the I am submitting for my lordship, like I pointed out the calendar. If they want need to fulfill certain things, then as the authority undertakes, I get the finish. Second aspect, my lord, annexure B, which are my explanation in detail, which are given as in page 19. For each of the shortcomings which they have pointed, I have given a detailed explanation. That reason is not forthcoming in the order impugned. Therefore, my lord, I am impugning this order on the basis of them exercising jurisdiction beyond the time stipulated. Second aspect, my lord, is deficiencies really are minor. The third aspect, my lord, is arbitrariness, because persons who are similarly placed, I have filed an additional set of documents which I showed to them. have been given conditional permission. And what I request the Lordship serving other colleges, similar circumstances. But the issue is the permission expires by July, August in the particular year. My college is already established. My Lord, in terms of the
Indian Medical Council Act.
Can I pass on?
Show it, she will be able to take it. Talking about the Medical Council Act or the
Central Council.
IMCC?
Of the new act, national.
What I learned one here what happens is
Okay, one moment. Kindly see section 28 airport.
Is extracted? Let's get this way.
before reading 28F, my lord, 20 PA. Field code, David code.
Yes.
Case of new act. Section 2. Notwithstanding the repeal of the act, the purpose of section 1 should not affect previous operational acts or repeal or anything legally done or suffered thereunder. Any right, privilege, obligation, or liability or incurred thereunder. The act so repealed. Any penalty incurred in respect of any contravention under the act so repealed. Or any proceeding or remedy in respect of any such right, privilege, obligation, penalty as aforesaid. Any such proceeding or remedy may be any such is that act this that
So when is the coming into force of this act? All right. Yes, that is, even if it is going to come in 2020, you're now differentiating between 18, 19 and after the coming into force of this.
Subsequently, I complied. That's why I gave you. First, compliance for the past 2 years.
No, subsequently you have complied means you have fulfilled the deficiencies.
Yes, other
No.
all these deficiencies, what they want.
You have been granted for 21, 22.
Yes.
For 18, 19, you were rejected.
Yes, at 22, 23.
For 18, 19, the note at page 24, what you read, you were given time till 31/12/2018 to fulfill the shortcomings and rectify those deficiencies. Have you rectified? You have not rectified. That's why you are rejected even for 19 and 20.
The deficiencies which are pointed out in the short notice, nothing is going on. Those deficiencies are all subsequent to their showcase without anything new shortcoming. Therefore, slightly whatever shortcoming is secure.
No.
It continued, my lord. It's the same point.
How does it get implied and how does it get deemed that it gets cured?
Because it's the first it's reference to yoga team or a web-based computerized central registration. I'm saying for my lord, if that effect continued in the next, then it would mean that I have not cured the.
Now, are you arguing or canvassing the theory that in view of your subsequent grant,
Yes.
the previous grant gets cured?
No, all I'm saying is as of today, that college meets the legal requirement set out by the authorities. Students under the protection of this honorable book, even though it is subject to conviction, have continued their education.
That is by virtue of an interim order. But still, you will have to still fulfill all those shortcomings.
Would have been saying is that the fact that 21, 22 and 22, 23, if I did not, because the standard remained the same from 16, 17, 22, 23, standard never changed. So if that standard remained the same, and it is only because I met that standard in 21, 20, it gave me permission, and 22, 23. Therefore, I'm saying for my first side, that as a shorter, because one is of procedural regularity and time. If that compliance was not there on that, and that's why the earlier order of my central government and the responding authority come up with a proposal, keeping in mind that other institutions similarly placed that placed the memo separately. And all of them have had waiver. I'm not saying that.
Obviously, that interim order must be subject to the outcome of the.
Yes, no, but they did not have come to the sound court.
No. Interim order of coordinate bench of this court in the judicial.
Before my lords, which I am subject to is the outcome. What I'm saying for my lords is that I had obtained subsequent RTI wherein I filed it on 25 lakh and I placed it for my lords that institutions who had even waiver shortcoming were given conditional permission.
You want to rely on that?
I'm under the bus.
So this will be something like, as it is, you are going to be drowning. So you're going to pull two more along with you.
I suppose there are two more.
Yes. So if you want to, you can place it. Then I will direct them to conduct again. There's an order passed.
Similarly placed.
There are two separate arguments. What I'm saying to my lord. keeping in mind that I'm compliant since 2000. As the earlier order I impose a certain penalty, which should be something which is a burden on me. Therefore, I will be more vigilant to make sure that.
That is what he said, that you go under the 28F.
Even if I go there, it's an academic. What happens is, children who are now studying, they would not have the benefit of all. Unless those children are protected. But as I said on the 58, this is an order before review. So this order still continues in force. And I'm going before, and the coordinating bench did not consider the. So if I go there, children who are with me are no longer given protection.
Yes.
They were supposed to record all this, which have been done. They were supposed to record all this even videograph. So the contraction is short. Keeping in mind that 21, 22, 23, if my lord needs to consider that they have been already directed to come up with how they have treated institutions similarly. And if they can wrap on my number, this is the identity of non. They invite us to those 3 years.
Yes.
That is the help of my notes. Earlier, how can we learn that so far known as an issue. Later on procedure and even if you take for a minute that so that is the provision which they are is applicable even to existing colleges. I submit for my lord that they are not following procedure, even contemplated on the termination of the 1970 Act. Can I pass on one copy?
Yes, I have.
1997, chapter 58.
Yes.
It says under the heading itself, permission for new medical college courses. And then subsection A, under 1A, no person shall establish medical college or no medical college can open a new or higher course of study or training, including a postgraduate course of study or training, which will enable us to qualifying award community or increase its admission capacity in any course or study or training, including the postgraduate study. Now, you see the procedure in the subsection 4. That is the procedure which they have relied on. On the central government and the central council, you obtain such other particulars as may be considered necessary by it from the person or the medical college concerned, and thereafter it may, if the scheme is defective, does not contain the necessary particulars, give a reasonable opportunity to the person or medical college concerned for making a written representation, and it shall be open to such person or medical college to rectify defects in any specified by the central council. So this is the first level. The level 2, B. Consider the scheme having regard to the factors referred to submitted to the central government, together with its implementation thereof, in the period not exceeding 6 months from the date of receipt of the reference from the central government. Level 3. Central government may offer scheme and recommendations to the subsection 4. After obtaining where necessary such other as may be considered necessary by it from the person or medical college concerned, and having regard to the factors referred to subsection. either approve the scheme with such conditions as may consider necessary, disapprove the scheme, and any such approval will constitute permission of the subsection 1. Please over. Section 8. Central Council, by making recommendations under clause 3 of subsection 4, Central Council will passing an order either approving or disapproving the scheme can have regard to the following fact: whether the proposed medical college or the existing medical college seeking to open a new or higher course of study of training would be in a position to offer the minimum standards of medical education as prescribed under Central Council under Section 22. Whether a person seeking to establish a medical college or an existing medical college seeking to open a new higher capacity or increase in admission capacity. My submission for my lords is that 13A would not have been applicable for the present procedure. Now, my lords, please see section 22, which is reference to
Neo, now you read 13.8. 13.8 also says proposed medical college or existing medical college.
Yes, they are offering new courses.
Right. Oh.
Higher courses. New or higher course of study.
All right.
Section 22 says the minimum standards of education. The regulations under 22 cannot control provisions of 13A. 13A can control the regulations. 22 provides for regulations. Minimum standards of education in Indian medicine. Central Medical Council will prescribe the minimum standards of education in Indian medicine required for granting recognized medical qualifications by university boards of medical education. Copy for the regulations. Now the regulations, my lord, and feature under the regulation, I placed in the recommendation, which is at page 6. Page 26. Mention D. These are the regulations. The power comes under 36J. 36, section 1J of the Act says standard of staff, equipment, accommodation, training, and other facilities. 1J.
Where are you reading?
I'm just saying the operative, the power comes, the regulations under 36 1J of the 1970. 36 1J.
36 1J. Let's read it.
Standards of staff, equipment, accommodation, training, and other facilities for education in Indian medicine. So these regulations, which are used by me at Annexure D to my petition, comes from the source of power.
Yes.
But here they say, if you see the regulations, requirements of minimum standards to grant permission. That's number 1A. The Ayurvedic colleges established under section 13A and existing under section 13C of that, they are attached that fulfill the requirements of minimum standard for infrastructure.
You are reading 22?
No, I come to the regulation.
Where is that?
That's the big petition.
Page.
Page 26.
Yes.
This is the regulation.
Yes.
Under 3(1)A. 3(1)A. The Ayurvedic colleges established.
So this regulation is, I think, changing continuously over a period of time. Or is it standard? This is 2016. Nothing new has come into force yet.
Some say that the same standard. 3(1)A. The Ayurvedic colleges established under section 13(3) and existing under section 13(C) of the Act, and their attached hospitals shall fulfill the requirement of minimum standard for infrastructure and teaching and training facilities referred to the regulation 4 to 11. I'll underline this one, up to 31st December of every year for consideration of grant of permission for undertaking admission in the coming academic session. Therefore, even the regulations recognize the essence of time. The Central Council shall visit the college sumo 3 months before the expiry of the permission. Permission, my lord, as I understand, would be July, August. So 3 months before that. The pro forma visits as prescribed by the Central Council website will be online by the colleges and ministers, followed by hard copy of the same deadline issued by the Central Council. Section B. Videography and photography of staff and infrastructure during the visit shall be made by visitors and submitted along with their detailed report and observations to the Central Council. But I submit, my lords, that they have not done any videography, nor have they shared the report. At the end of the day, I am supposed to assist them to improve the standards of this, not purely for profit. After submission of the online detailed report and observations by the visitors and Central Council shall submit a report recommendation along with detailed report to the central government within a period of 1 month from the submission of report by the visitors. They visit on 24/5 and I get the notice on 9/8. The Central Council shall certify the teaching staff that will be present in the college. Possession prevail at the date. These regulations, set sub-regulation 2 of the regulation that were taken into consideration for grant of conditional permission or permission of period of 5 years. My lord, please turn the page over. Requirement of minimum standard to grant conditional permission for 1 year. Because I'm not for the 5 year, I for 1 year. The A, conditional permission of 1 year particular academic session granted on colleges. The fulfilling requirement of the basis of inspection of the Central Council between 31st December to 31st March for the succeeding academic session. And then plus B. Colleges which have been granted conditional permission or which have been denied permission to academic year shall be required to fulfill the requirements as specified above in B. Obtain the conditional permission for 1 year for a private regulation 4. My lord is pleased to see page 32. Page 32. Clause 12.
Yes.
Date of completion of permission process and cutoff date for admissions in Ayurvedic college. Process for grant or denial of permission to Ayurvedic colleges for taking admission in the Ayurvedic colleges shall be completed by 31st July of each academic session. Cutoff date for admission in Ayurvedic colleges shall be 30th September of each academic session. My lord is pleased to see page 38. Where notice put at the bottom.
Note.
Under subclause 3, the deficiency of teachers for up to 60 intake capacity shall not exceed more than 10% of the total requirement availability of one teacher each of the 14. Similarly, subclause 4. I'll just read this whole thing of 3. The total number of higher faculty will not be less than 12 professors. The relaxation is for seeking conditional permission under the admission for an academy. For example, the college having 60 professors has minimum 27 faculty, each 12 professors or leaders, having not less than 7 departments. What I'm submitting for my Lord's time consideration. A is time stipulated. B is there is a margin provided. And the last but not least is that the provision enforced is under the regulation and not under the PPA. And if they would like me to comply, and they should, if they follow a particular procedure, so long as the procedure does not cause any harm, there might be some areas permitted by law. But if causes prejudice, so the whole purpose of considering this is and reinforcing timelines as mentioned E is to discipline everybody to come on the same page. Here, my lord, they would do as they wish. They would follow no timelines. And in this regard, my lord, they would also consider that we see in page 2. Other colleges, and annexure here, where 193 colleges.
Lecture? Page?
52. More than 190 students.
Colleges
Colleges.
are granted permission.
And the last ground cover is
Now, is it your case, annexure have all these colleges sorry are having deficiencies and so they've been given conditional permission.
And I've been placed on a separate footing. They could have aim a lot, they should have stuck to their timeline, to insist on me. We having delayed, they could have told me that listen, we are going to give you so much more time. And now I'm completely compliant because I'm following the same process as all other colleges. And I have petitions for 21, 22, and 22. And to further demonstrate this, my lord, I filed a memo.
What did you find?
Memo with further document on 25/9/21.
Page?
32.
It starts from some other numbering of 300 onwards.
85.
Yes, Dilip Gowda. It started continuation. Page number 32. Now, what is the subject?
But here, what is showing?
What is the date? It's page 413. No, you will have to update yours, and they may also, you may not have updated their book also. 7/8/2018. Hmm.
Not just the other services.
Yes.
So, and then my lord, this shows my lord in this first college. You might also have shortcomings. Please come in face the following page. Teaching staff. There is no Sanskrit teacher available against minimum requirement. There is shortage of one higher faculty in the Department of Education. The shortage of one and non-teaching staff. No library. Hospital staff. There is no assistant matron. There is existing 16. There is one dresser against 2. Functioning. There are no deliveries called perform. Animal house not available. And if you are not please turn page over.
So how do you say they have not fulfilled?
They give a conditional permission.
Oh, the para 6 you can read.
It should be verified for granting permission from 2019, all the requirements. Fulfillment of conditions attached to the permission may be given within the time prescribed. Within the time prescribed. And this is one of
no, para 6.
yes.
The college is also
The
correct.
recommendation there. Shortcomings. Fulfillment of the para 6, the college is also directed to the following, which should be fulfilled by the college shall be verified, granting permission. All the requirements of minimum standard, all the requirements. Fulfillment of the conditions should attach to the permission given above, it is within the time being specified. CCI will verify the means of the inspection and submit a report.
So is it your case that despite this college not fulfilling the requirement, they have been provided the conditional permission?
Yes.
How do you say so? Because you are not privy to the, it is not between you. It is between the college and the authority and the central government. Where para 6 says that if you do not fulfill, permission will not be granted.
See, page 45. Same. 32 plus 30, that means it will be 426. 26. Item number 14.
426.
Same college.
Okay.
They have been granted permission and time to come. That's the point. Similar to the item number 5, 7. Now we'll come to the opposition.
So you are saying that you should also fall under the category of conditional permission and provide time for you to comply with it.
So they've done that with other colleges. Similarly, placed. The same thing is that increase 69. That will be 52 plus.
That is 20th August.
Yes.
451.
All the colleges. That's the reference to this one.
Yes.
The other aspect is that hearing committee, because the reports they have not made. Hearing committee contains 2 members. Not the petitioner. Only 2 members.
What is the constitution of the hearing committee?
Neither of them is not Ayurvedic.
Where is the constitution prescribed? There's a provision, I think, under the Act for the hearing committee. No, the inspection, the hearing committee constitute a certain number of persons. Yes, it goes to the central government. So who are all the persons sitting in the hearing committee?
Of my grounds in page number 11 of the report. One is one Dr. Nambudri.
Page number?
11. One was member of the homeopathy.
Page number 11.
Yes, 123. Because in the impugn order, they say that the designated hearing committee, that in page 23, para 6, for the persons who heard. One member of the homeopathic committee and another was the Ayurvedic doctor. I completely bow or respect what my learned friend says that you might confidential. This is a procedure I can be transferred.
You have participated before the hearing.
I'm only saying that the constitution of the committee.
No, then how can you say petitioner?
Every person, one is homeopathic, one is Ayurvedic.
All right, you said names of the hearing committee members not disclosed.
Yes, this is because we can't say that they are affidavit. We probably ascertain that these should clarify whether it is actually right or wrong. We are filing an affidavit saying that these were the 2 persons. But we have ascertained this. Therefore, I'm submitting my note in light of their own conduct. Even in addition to the timeline, having given conditional permission to other companies, I've given them, I could have been put in the same basket as the others, given that time so that I can. And there is no material for them. Such draconian measures were necessary as contemplated.
Yes.
And last but not the least, that the subsequent years of the risk of revenue.
How many are the members? 2 members. Fan on must be. Madam, get the fan also put.
It's not to ignore the reply. The purpose of the show cause notice is to say, what is your stand and why I don't, the eventual order should reflect consideration. I used that direction field. I would submit my law. Remain uncontested. Because I have specifically point to point, see page 19. I have said this is what is there, these are the persons. Web-based compute, right? For instance, because I don't want to cover it back. I'm just saying, there is one yoga teacher, that is the objection raised by them. There's one yoga teacher, is going to report. Here I am saying the following specialists are working as visiting specialists, the appointment level, and schedule 5, in page 38, says what is expected. Schedule 5 in page 38 says what is the requirement for teaching staff. So I have given a reply. Similarly, web-based computerization investigation, OPD, IPD as per RLS CH-22. They are computerized investigation where the data related level by the hospital, office staff and data record related to SLV, along with the fact.
But you're reading where?
Page 19. That is my reply to the Ashoka of the report.
This is a reply given by you.
Yes.
Yes.
And what is expected, like if you take the
So
first item,
after this 20th August 2018, was any further inspection conducted? What is the order after this 20th August?
2018, we should see. The only reason is the parallel. In para 2, they repeat what is written in the Shukwa notice. Para 3, again, what is there in the Shukwa notice. 4 is the undisclosed recommendation report. 5 is the Shukwa notice. 6 is my hearing committee. 7, whereas in view of the observation of the hearing committee, based on the submissions by the college representative, hearing and recommendations, refer to and the visitation report of CCI refer to para 3 above. Para 3 is the earlier to the show cosmos. Therefore, what fell for my lord is that if I've given a matter of fact, it was for them to say that these facts are disputed.
Okay.
And we see, my lord, I mean, and this is not a problem, my lord. Actually, when we look at my reply, which is in page 19, first is they say yoga teacher. And this relates to schedule 5, which is at in page. Item number 7. Which describes one teacher. And they say themselves, there's one yoga teacher against the relaxed requirement. And I've given the details. And the next thing they talk about web-based or unified registration system. The requirement is that in page 28. That's at the bottom, serial number 7, subclause 3. Maintenance of record of attendance of outpatient and inpatient department patients. Subclause 2. For conditional permission, college and hospital will maintain the computerized administration system, maintaining the records of patient inpatient. College will also maintain department-wise outpatient inpatient records. Well, this I have given an explanation saying that I have it. Then the next they say there is one EMO shop against the requirement of EMO. I have given a detail. The standard is again of page 6, where there is a requirement of 2 officers, item number 4. I have said that who are the persons who are available. Similarly, for physiotherapists, the functionality of OT.
What's your explanation for that, OT?
But we are conducting Ayurvedic surgical procedures like this is also in our operation.
What is that explanation? Reply.
Item number 5.
5.
The standard is stipulated at increased regulations. Operation theatre.
All right. Now, when they say something and you are controverting, then there has to be a joint inspection and survey.
That's what. Therefore, I don't.
No. So then it should have been done then, not now.
Cannot be done.
No, it cannot be, obviously, because we are now in 2023, which permission is granted by you. They may have fulfilled it or not fulfilled. We don't know. Yeah, you're finished with your argument.
No, that's what I just. After the show cause notice, when I have placed actual material, should have been followed up.
Pursuant to a reply, nothing has been done.
But they are referring to the earlier inspection report. The authorities, my lord, I have some.
You can place it.
I have already filed it. And this highlight what is the submission. One is in terms of using terms of this, I filed it on 25/9/21.
I have one list of authorities given by you, dated. Even in 47281, there are certain authorities.
Yes, it goes up to it.
Yes.
Page 13, reference to minor deficiencies. Para 11.
Page
13. The page 13 of the judgment. Vision page. From what I understand, my lord, is there is no further. This is already in final care.
Yes, you can read what you want to.
We will notice at this juncture itself. Prima facie the objections raised do not have adverse impact on the studies that will be undertaken by students. Then page 15. 10th line. Material.
Yes.
The material being available. Corresponding number 1, along with the report. Certainly, it's good, but otherwise it is unconventional. The supporting document, reading the report of this dash exercise fields have not been undertaken, as could be seen on the 29. Elsewhere. Yet another intriguing factor is that respondent 1, the last include order, has not only already taken into consideration deficiency pointers and so on. By naming the deficiencies pointed out as if there are also certain other fresh deficiencies pointed out. Like, but the finding, procedure of finding or not, it is not the CCI was looking for. That was the P. Sorry, I think around paragraph 16, last four sentences before paragraph 17. In fact, with regard to the deficiency provision 3, referred to supra, it relates to administration. And it may not have any direct on the course with which students to undergo an undergraduate status. Just MP. Paragraph 17. Already PG. Your this background, the adjudicating authority, he first responded by examination, also have recorded its subjective satisfaction based on objective assessment. The exercise seems to have not been undertaken by the first respondent. As evident from the finding of fact, subsequently from that. Second judgment, my lord, that is A versus Union of India. Start from UK. 29. That is just before paragraph 8. This is the sentence.
Which judgment are you reading?
This is A. Second judgment. AIR 2017 S. 4033. Start from page 26.
No, the pagination is not right. There's a continuation pagination.
I know.
Because they've started continuation after this. Your citations begin with page number 213.
Isn't that judgment is 213?
Yes. It begins.
This is 239. 39. Then 39.
Para number?
9. Then Polo Institute of Medicine.
Yes.
Paragraph number. Paragraph 8. That's at
So Mrs. A. It's not Mrs. A, it's Apollo. You have made it Mrs. I'm searching for A. We all learnt in the school find X. Now I have to find A. All right. So that is judgment of the Supreme Court.
Yes.
Yes.
242. This is for paragraph 8. Reasons to have been
Just before para 8.
Yes.
The
The last sentence. Para 7.
Ah.
No tangible reason whatsoever been assigned by the state authority in this regard, even alone any reason. Therefore, my lord, we should have given a reason.
Yes.
44.
Para 63. Yes, since the regulations.
Yes, since the regulation.
Hmm.
You got supply, but I will allow the. Unreasonableness, arbitrariness, unfairness, is alleged a violation of fundamental rights or exercise of powers beyond the legal limits. I say for my Lord's time consideration that after the timeline stipulated, the authority did not have the jurisdiction to pass such an order. And following the principle of manifest arbitrariness requires something to be done and exercised in the form of delegated legislation which is capricious, irrational, or without adequate recovery. Delegated legislation. Therefore, my Lord, even the persons who are concerned should have taken the effort, keeping in mind the citizens who are going to study. P39 is P39. The moment is that here.
Yes.
Para 23.
On what proposition?
Question of Article 23, 24, 25 says similarly situated. Then I just distinguish the three judgments they have relied on it. One judgment they rely on is Central Council for Indian Medicine.
Yes.
But in paragraph 30,
Of which judgment? You have relied on some citations. You placed it on record. Yes.
but in this judgment, basically the Supreme Court was concerned with how to go beyond the statute. Paragraph 32. Paragraph 33 about the Supreme Court says, beyond minimum money. We have to convert. The question of we not following the time. They're not making a finding of fact.
Which is the division bench judgment which has been set aside?
Arise from relatively 41.
Which is that is on record? Yes.
The only bench judgment. Which is concerned about the parity. Additional intake of food.
Sarah? Yes.
Intake of food.
That is only to reconsider.
Yes.
So, yes, that's all. Yes, who wants to begin? Must be the same.
The second
That is also by an institution.
Here, my lord. A lot of cases, I mean, they again don't follow the timeline.
So there also you have permission for few years and non-grant for few years.
Yes, this is the first one was 2018-19. Second is 2019.
And even in the third matter?
Third matter is for 2021.
All right, similar legal arguments.
Yes, largely. But what they do in this matter, they replicate the Shoka's notice. All other submissions aside. Whatever, see, Shoka's notice is at paragraph 3. In 24, this is Shoka's notice. So the third paragraph is Shoka's notice. Please turn to page over, see paragraph 5, it's at page 26. Just a repeat of the entire Shoka's notice. And then paragraph 8, whereas in view of the shortcoming and deficiencies mentioned above, it is found that the college page 30 is not fulfilling the requirements as indicated. Therefore, and denied permission. Therefore, my reply, or whatever documents I produced, is completely ignored. And this again, the third writ petition memo proceedings page 38999 of 2021. Show how they very casually would take this up. That is grid petition 38999. And what I'd like to request a lot of kindly consider, for the first time, we actually make an effort to analyze whatever my lord is still proceeding. In page 22.
Which rate petition?
38999. 38999.
22.
Yes, sir. In page 21 it starts. 22. They put out shortcomings survey. Then they, my lord, this is turn to page 23. They put observations. Then the remarks for each issue. So for the first time, we follow a process. And this order is dated 16 to 21. And page 28. Paragraph 12. They direct me to complete it by 31st December 2020. So they send me the order on, it's dated 16 to 21. And they say that I will finish it by 31st December 2020.
Yes.
So the basic principles would be the same in terms of timeline and considering the.
Yes.
Ask I just read out the three sentences. My learned friend placed all these comments. That is Dental Council of India versus Interim. 2017, 30 CC 1. You get that the High Court that the students should not be put at risk. That is places.
That's a judgment of?
That is after the
No, the judgment of this court. Students should not be put into difficulty.
Students should not be put at risk. That also.
That is protected anyway. They're protecting the interest of the students.
That's why I said.
By order, it may not. Yes. CCA. How much time you will take?
But you have their order, their okay, so all these things. You can pass an order. Now, by virtue of the act, you had put them
That's why I asked. That is why I asked, because I think you can continue tomorrow. The others are waiting. You can continue. How much time you will take tomorrow? 45 minutes. This legal submission, you can restrict it only to that. No, you are only their recommending authority. You are the one who has to consider and pass the order. All right, we'll list it tomorrow. 2:30. Heard Learned Counsel Ajesh Kumar for petitioners. Learned Deputy Solicitor General for R1 and 2. Learned Counsel Srimati Manasi Kumar for R2. And learned the counsels representing the university, that is Rajiv Gandhi University, in their respective writ petitions. Release this matter tomorrow for further hearing. 2:30. If you are relying on any site, you have given copies. You can place it. Yes. So I think that is what the Supreme Court has said in several cases. That the high courts across the country should stop giving these interim orders. Not latest in 2018 Ranvijay's case, and even prior to that, I think I have myself passed an order. And I think they have come down heavily in NTR. I think 5 crores or something has been cost is important. Kalingar NTR. So this, whether be it Ayurvedic, medical, or homeopathy, or whichever, 10th standard or 12th standard, the sympathy aspect is to stop somewhere. Otherwise, we are heading nowhere. But, yes, yes. So somebody can take notice from your side. Please show his name. Shiv Kumar. Parkoli. Mr. Budala Shivaya. And so serial number 24. Learned Deputy Solicitor General of India is present, along with the petitioner party in person. Learned Deputy Solicitor General submits that the senior panel counsel, Shri Shiv Kumar. Shiv Kumar has been nominated by the central government in this matter. His registry to show his name in the cause list. Relist this matter. We'll have it on Monday, 13th. All right. We can. All right, 10th. We'll have it on 10th. Relist on 10th. There is Mr. Ulal. All right. So you are able to access. Yes, this is a serial number. For the request of learned counsel for the petitioner. Release this matter tomorrow. ನೀವು ಸಿರ್ಸಿ ಅಂತ ಹೇಳಿದ್ರಿ. So So what he's submitting that they're already making an effort to fill the form. If the portal gets opened and if he's permitted. Date is extended. 15th Feb. All right, then we will have it on Monday, 13th. No, it's tomorrow. Day after tomorrow. No, 10th. List on 10th. No, 230 metric. Pawan Kumar, 56. Yes, Girish. No, that's okay. You are in the earlier case also. Huh? No, in that matter which was argued, 45 serial number which was argued earlier, just now, that Mr. Jish Kumar and Manasi, you are in that case also. You are not here. Yes. What have you done in this? He is seeking for 4 evaluations. Same methodology which is in the regulation. What's the difficulty?
Page 32.
One minute. Now your prayer is for evaluation by way of 4 evaluators. So now you have evaluated by 2 evaluators. And the results are published or not yet published? Now this declaration, the evaluation by 2 evaluators is by average or 2 of the highest? Average of 2. This also addresses erratic and deviation evaluation. Which is that on page? Of by whom? Page 7. This regulation, this notification 29th March 2019 is not set aside.
Still, what relies upon the petition is based on the central regulations. Central regulations, they themselves. And that was not what the rules of, but still about a 70%.
Where do they say in this notification for evaluating? That is as per CCM guidelines. Yes. The central regulation is CCIM. Sorry?
CCI.
Where is that? R2, is it? Regulation 2016. So that is the relevant portion. Similar to the same medical and dental and others also. Same ditto. They made a notification also.
Onwards. It is not a one-time repetition of this regulation. Change some, make some changes. For example, they have indicated. Final paper consists of 4 theory papers and 1 practical paper. For 1 practical paper, they have 4 variables. But for the 4 theory papers, they have given only 2 variables. So that is the illegality process. According to the regulations, legally can reduce 2 variables marks.
What happened? Where is the deviation valuation? No, in the central legislation, there is a university regulation. You have petition 34. That is the 29.3. So they differentiate between PG medical, dental, and then homeopathy and allied sciences.
And on the basis of this, they have 2 valuations for me.
This has been set aside.
Set aside. So they have
Let me complete, then you can argue.
of course, in the specific regulation, then started in PG.
Yes.
Section 3 is a general ordinance relating to all the PG cases.
Yes.
In the general ordinance, there are many PG medical, dental, and PG Ayurveda. Now that distinction, my respectful submission was removed. PG notification dated 14/10/2020. So that was just an enabling problem for the country. There was no CCM regulations, there was no election act, there was no parliament. Now they have the central regulations. Central regulations provide for valuations. PG medical, they have basis notes for your system of more people. For practical anything knows the market definition here, page 35. 4 values, 2 external and 2 internal. Theory, that is some valuations for 5 valuations. It's deviation. It's 30.
It's only by 2.
So this even this part.
Yes. Maybe you can use the mic. More. Yes. It's already on. Just tap it. Oh.
This ordinance is for the boundaries of page number 18, my lord. This is a notification that being empowered that on which they should make an ordinance. This is not an ordinance. It be a yes, I actually. What is the ordinance? Because this is from 35 plus 2. A lot to the started this ordinance.
So this is not concluded into an ordinance.
This is the notification that have the
Adopted what?
regulations
Of. Correct.
Attended for clearing 4 papers. It is subject itself for all the 4 papers. Whatever the regulation that is there. What do we evaluate?
No, now you have evaluated by the methodology of 2 evaluators. That is in consonance to that.
Ordinance dated 29/3/2019. Page 32.
This notification of 29/3 is declared as unconstitutional. Who are they? No, who are they? Then this notification goes. Then how you have to evaluate? Then you do that. No, he has already taken the exam. Subject what? Right.
Pass marks, this is subjects. Pass marks is, even if you get the pass marks is 50% in all the papers. There is no individual pass marks for each subject.
So you want to subject yourself to revaluation for all the papers. 4. In case now you, after revaluation by methodology, if your marks gets reduced, accept that. You are passed in 2. No, this is valuation or revaluation of. Why would you go for pass subject for revaluation?
There is no pass for each subject.
No, you have now out of those two valuation methodology, you have out of 4 theory subjects, you have passed in 2.
There is no pass in each subject. Pass in aggregate papers. For each subject there is no pass. If I get 40 in one paper, then I get 60. So the one. So you cannot say. You cannot,
So you have to subject to all the papers. You agree? You agree to that? You subject to all the papers and you conduct fresh valuation of all four by methodology of 4 valuators.
This is the downward direction. There B.
Yes, sir, I have. You cannot go contrary to the central legislation of CCM, which prescribes 4 even according to you. All right. So when is the next exam in case you declare the results and end of February? Yes. So say I will proceed to pass orders. Third, Learned Counsel Shri Senior Counsel Shri Ruben Jacob for appearing on behalf of Pawan Kumar MN and Learned Counsel Girish Kumar R for respondent number 1 and Sandeep Christopher. He appears for college.
2 years. Yes.
What's his role? Nothing. Formal.
Since the common parties, in fact, they have.
All right. So and so. Release this matter on. We'll have it on Monday. I will dictate. You are relying on any judgment? No. Send this to my number. Send this back to my chief. You have given. All. Yes, Balraj. $55. Your file of color. What is your name? J. J. Samuel. Joseph. Joshua. All right. Learned Counsel Sri Maruti is present before the court. Submits that they file wakalat on behalf of respondent number 4. Registry to show the name of Joshua and Samuel. Joshua Samuel as counsel appearing for R4. Yes, what is this? First PUC. Where is that? Page number 66. Commencing from 20th. You have taken which course? Huh? What is that? Where is that? CB. CEBA should be either computers, economics, business studies, and accountants. Yes, what is the difficulty? No, this is a private. Are you granting it? You're not aided. %75%. How much he has? 1.5. Why you have no attendance of 14? Diagnosed as? Where is it? Page. This year admit and discharge and diagnosis. $43. Where is the diagnosis? Liver abscess. No, you are admitted on 28th August, 22nd August. Where is it? You are discharged on 29th. Page. Hmm. Where is it? Left above knee. Amputation. 25-10-22. Well, how did you met with some accident? When was the accident? What is the date? 10. No, but you showed 14-8-22 earlier. So accident on 24. Huh? So he has 15%. What was his scoring marks in the previous academic year? Show that. Page? A grade. For PUC 1, the marks cards are issued by you only. Where the question of university? No, but do you have to go back to the university for attendance and other things?
Well, sir.
The 12th also.
Well, sir, they themselves have to enter into the portal. The college melots, they'll enter and submit it to us.
But for first you also they are governed by the university.
We don't ask them melots. They'll only themselves they will send it to us.
To the state government, you'll have to send it to the state.
Please, fellows.
The university, that is by the state only.
Please.
That is DDPI.
My lords, respondent number 1 and 3, my lords, they have 2 and 3, my lords.
We'll have to grant the permission.
No, we don't have to grant permission, my lords, but once it is entered into the portal, then it can't be changed. Can't be changed, my lord. Otherwise, everybody will start changing it.
Well, now already you have filed and rejected.
My lords,
pay the fees. There is a last date. So the exam is scheduled to commence from 20th February. When is the last date for payment of fee and other things? All right, what is your instruction?
Lord's fees is also collected by them only.
Correct. Now you're a private institution. He's a student who's now encountered certain road traffic accident. In view of the special circumstances, you allow him kind of having taken the fee, upload it and send it to the government, respondent number 2 and 3. Yes, madam. Government, what do you say?
Well, I could not follow what the council said, but once if it is already been sent, my lords, we cannot. It is not permissible, my lords, to change as of now.
No. The last, have you already sent the list? I will pass an order directing you. What, madam? Pursuant to order of the court.
My lords, first PUC, my lords, if the institution
of
can
the college,
please,
by
ma'am.
virtue of an order of this court, he will make separate some more alteration or correction. And then he will resend it to you, permit it on the basis of a special case. Because though he's not complied with the requirement of 75%, he has met with an accident, he has lost his leg.
Not as per the regulations and also with judgments of this Honorable Court and Supreme Court, attendance is mandatory. It can be reduced only to, there'll be a percentage, my lords, for which they can reduce. Generally, it is 80% and 5% reduction for all these things can be given. Not beyond that, because the academic learning will be altered, my lords. It will be, impediment will be there. Therefore, they can, my lords, they can give the examination, my lords. There may not be any order to upload once again because it will set a precedent, my lords. There may be an interim order to write the examination, my lords.
All right. So you exercise your discretion and send it across. I will permit him to write the exam by you collect the fees and issue him hall ticket, subject to the outcome.
Very well.
It will not be, sir, once you allow it from your side. Once you do it from your end, it will not be an order of the court. Why you have not attended for the other days apart from this period of accident?
Had they approached earlier, my lords, they could have, the college could have sent it, given some relaxation and sent it. Now they have approached in the last minute.
All right, he has been now admitted in the hospital and he has lost his leg. He is not a very poor student.
Lords, there could be an interim order to permit him to write the examination.
Heard, Learned Counsel, the Balraj AC for the petitioner, Learned AGF for respondents 1 to 3, Learned Counsel Sri Maruti appearing on behalf of respondent number 4. Full stop. Petitioner is a student. Having completed his 10th standard, pursuing his first PU, pursuing his first pre-university course in the combination of CEBA. He was admitted for the batch 2022-2023 on 18/7/2022 with an identity registration number of ID number 428/2022-23 by the 4th respondent college. When did the classes commence for this batch? August or July? It is stated that the classes for the set first pre-university of CEBA commenced during July 2022. Unfortunately, the petitioner fell sick on 14/8/2022 and thereafter met with a very unfortunate accident wherein his right leg above the knee has been amputated. Left leg above the knee has been amputated, documents of which are placed before the court, due to which petitioner could not attend the classes and hence he was in shortage of attendance as prescribed by the college and the pre-university board, due to which he is not permitted to take up the examination due to want of attendance requirement. An interim prayer is sought for to permit the petitioner to take up the examination and for a direction to the respondent number 4 to permit the petitioner to write the first pre-university examination, which is scheduled to commence from 20th February 2023 to 3rd March 2023, as per the notification issued by the third respondent, which is placed at Annexure F. Direction to 2 to 4. Having heard and being satisfied with regard to interim prayer, I deem it appropriate to pass the following interim order in favor of the petitioner. Respondents number 2 to 4 shall permit the petitioner to appear in the first pre-university examination, which is scheduled to commence from 20th February 2023 to 3rd March 2023. Petitioner shall pay the examination fee along with late fee. Pay the examination fee along with late fee, if any. And the second term fee of the college, and on payment of such fee and being eligible, otherwise despite the shortage of attendance, the respondents 2 to 4 shall permit petitioner to take up the examination, which would be subject to the outcome of this writ petition. On payment of such fee, along with late fee and other fee which is due to the college, the respondent number 4, which is the college, and hall ticket the respondent 4 shall issue admit card bar hall ticket to the petitioner to enable him to take up the examinations, ensuing examination scheduled to commence from 20th February 20. Taken notice. The third copy on let me add one more thing. The petitioner produced Annexure A, none in the 10th marks, which shows that he has passed in A grade in the 10th class.
Let's let it be subject to eligibility criteria apart from attendance minutes.
Yes, I've said so. Subject to all eligibility criteria, despite the attendance shortage.
Please.
Yes. Navadia. 54. ಹೌದು 54 ಅಲ್ಲಿ ಗೌತಮ್ ಎಲ್ಲಿದ್ದಾರೆ? This is Kiran Ron, Kannur. You're appearing. Kiran Ron. So you want to continue with this or withdraw this? Albeit you file whatever you want. No, that you give it. We'll have it day after tomorrow. Tomorrow may not be possible now. It will not come. Release this matter day after tomorrow. At request on 9th, at request of counsel for petitioner. You can serve a copy, let them go through. Yes. Release this matter next week. The matter is called out due to paucity of time. Though the matter was called out twice, there was no representation. Hence, release this matter next week. Who's R3? Who's R3? Who are you? Who? Petitioner who? When did you sell? 1960. You sold it to the respondent number 3. Yaro? All right. What is restored? After how many years?
5 years.
Like a Kumbhakarna, you have been sleeping. So no relief to those people who sleep like Kumbhakarna. Read the judgment of Katiji, I think Isha Bhattacharji. So your petition will not survive. Go read it and come. Take the judgment. ಗೊತ್ತಿದ್ಯಾ ಯಾವುದು? Isha Bhattacharji. The limitation. Though there is no limitation under the SC/ST Act, but reasonable time, even under that Nikanti Lakshmama, Ramalakshmi case. Not tomorrow, was next week. Read the judgment and take the other 2 judgments from him. At request of learned counsel for the petitioner, released next week. Shanmukha. Within time, after time. No representation on behalf of petitioner. Learned HCGP is present for 1 and 2. Released next week. Due to want of time, release this matter after 2 weeks. ಏನಮ್ಮ ಹೊರಗಡೆ ಇದ್ದಾರ, ಒಳಗ್ ಕರೀರಿ, ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಾ? ಏನ್ ಹೇಳಿದ್ರು? ಅಡ್ಜಸ್ಟ್ಮೆಂಟ್ ತಗೊಳಕ್ ಹೇಳಿದ್ರಾ? All right. Due to want of time, release this matter next week. Same. Itala. Why is Madam Mansi Kumar waiting? You're furnished already. But it's not here. All right. Mr. Government, in all these matters of SC/ST which are delay of more than 25 or 24 years, just tell them to get it posted and you have to make a list and give it to my court officer. We will get it listed because it will not survive. Simply we are pending from 2010-12, more than a decade over. Yes, make a list. Huh? All right, take a date, whichever you want to. 46, that SC/ST matter, just give them a date. Give a date next week sometime, 16th. You have to read the judgment and come. Take 2 more judgments from him. Wait a minute. ನಮ್ಮ ಬ್ರಾಂಚ್ ಗಾವಡಿ ಎಂಡರ್ ಇದೆ ಅಂತ. ಸಾಹೇಬ್ರ ಕೇಳಿದ್ರಾ ವಾಟರ್ ಪ್ಯಾಡ್ಗೆ ಹಳೆ ಬಿತ್ತಲ್ಲ
ಏನಿದು